Morning, everybody. This is a resumption of hearing 22 related to rezoning. Is anyone in the room that could start with Karakia, that would volunteer?
Yeah.
Yes, that'd be great.
Right. Wakatako ki te uru, wakatako taonga, kia mā kine kine ki ita, kia mā taratara ki tai, kia hua, te huka, te tio, te hei, mauri ora.
Jeremy, I think we've only missed once. Can manage to start with a Karakia so that's fantastic. So just bring everyone knows myself and Commissioner Little John, Kit's leaving in from Auckland. He's got some family logistics. That means he needs to zoom in today. Welcome, Kit.
Tēnā koutou. Good morning, everyone.
And I'm Stephen Dace for hearings here. We do need to have a good discussion at the start about our two-day hearing program. I think it's been a bit of a mix-up. So we want to go through the four parties in the room. And before we do that, we'll just take some quick appearances. Starting with you, Christine.
Good morning, everybody. Christine, I'm one of the hearing administrators.
Good morning, everyone. My name is Matt Bowles, consultant planner on behalf of the District Council.
Good evening, Lauren Wallace, council for council.
Goodbye, Tim Heath, Assistant Council on Economic Matters.
Morning, everyone. Megan Taylor,
Megan.
Assistant Council on Transport.
Good morning, everyone. Kate Barricino for Blue Haven Commercial Limited Legal Counsel.
Hatamari, everyone. Jeremy Brophy, consultant planner for Blue Haven.
Bachelor, consultant. Great.
Morning, Sarah Edwards.
Good morning, everyone. Lauren Byrne.
And online, maybe starting with you, Philip.
Philip Brown, traffic engineer for Blue Haven.
Philip, you're coming in from Auckland, is that right?
That's right, yes.
Well, Ellen,
That's the Wonder Boom. I can't hear a thing.
struggles with his video. Marina Sarah.
Mr. Chairman, if I could just jump in while Mr. Littlejohn's sorting out his technology. When Jeremy did the intros just a short time ago, the sound was cutting in and out. So for us remotely, you might want to speak up just a little bit more so that we don't miss out on anything. Thank you.
Yes, thank you, Philip. We've been having issues. I think it's fixed with wearing headphones if you have those. I think that does improve that issue, but I was going to remind everyone to speak up. Mr. Heath sat through a day of whakakotahi evidence peering down the line, and he simply couldn't hear people in this corner here. So we'll do our best to be clear, and please speak up if you can't hear anyone. So back to you, Sarah.
O tēnā koutou, Sarah Mako te koteitanga o te Aotearoa.
Thank you. All right. So just a couple of preliminary issues. I think you're all aware that the panel was working under some procedures that we agreed with the parties as best we could for the hearings began in June last year. And just to confirm that Kat and I are two of four commissioners sitting on this hearing. Obviously, because of the links to the strategic objectives and the wider plan that the other two commissioners have sat on, we'll be looking at these issues, obviously not just discreetly in terms of this hearing, but in the round. So that's one thing. Secondly, just confirming we've got a recommendatory role to the council. We don't have a decision-making role, so you'll see some recommendation reports from us. About 40, I think, at the last count, the way we're organising things. And the last thing, I think is particularly important given this is a contested matter that all the commissioners have issued a statement of potential conflicts of interest in the work we've done around New Plymouth, both in the decision making and in the expert role. Want to check that all the parties are comfortable with both Commissioner Littlejohn and I sitting on this hearing and the other commissioners assisting with determining this matter. No concerns there? Thank you very much. And we do have a Zoom record of this, which means that we've got the oral evidence and questions available to us and everyone else who wants to spend some sleepless nights watching them later on. But yeah, so that's the routine. Now let's just go to the procedural matter. We have 2 days for this hearing. Sit down. And the only constraint is I'll need to be finishing up about 3:45 latest. Going to Asia for a couple of weeks and out of here, otherwise my life won't be worth living. That's the only constraint we have, apart from the normal board. So normally in a hearing like this, and change of resource consent stays the proposal will go first and then the submitters and then the council. But I think what's been arranged here that we'll hear from the council piece first through some opening submissions from you on that plan. And we have a presentation to go through that. And Christine, all the parties have received that, we know.
Not the other copy.
Not a copy.
We'll go up online like normal.
Okay. Yes, I've just seen this morning. I haven't seen it. So like everyone else, that'll go on offline after you'll read that. Yes, sir. Okay. Now, where I think we've perhaps got a little rise, there was some communication between Mr. Brophy, Julie, you and Julie about needing to finish or something about unless we take evidence as read, we won't get through your evidence today. We need to...
Yeah, my observation was that the afternoon has a lot to get through. So I had a few concerns of whether that was possible. Julie came back and did confirm that it was possible, taken as read,
Yes.
and then moved through it to questions. But further to that, noted that panel are not restricting time allowance, so experts and presenters want to present, that's fine as well. My understanding of where we've landed.
Yeah. But listen, our experience is that the right reply, so tomorrow we look at tomorrow's pretty skinny. We've got Road Devon talking tomorrow morning. We've got which next take half an hour or an hour if they can eke it out, and we have lots of questions. So my proposition is we don't rush things. We have read all the evidence, right? And we'll quickly scan the legal submissions over time. So the other thing we have to fit in tomorrow is Sarah Marco has been quite well. Sarah, I hope you're feeling a bit better today, as it has provided us a statement of evidence over the weekend, and I'm allowing you to come in. And will also need to be circulated probably ASAP, Christine, to the parties. And Sarah's asked that herself and Hapu, 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 heard more and more as well. So that's something that I'm happy to see too. Now, with that positioning of where we're at, does anyone have any questions or comments or constraints before we can finalise it?
Certainly, I think that works in comfortably with the council's team. The presentation that we're providing this morning is supplemented by a small summary from each of the experts, simply to sort of provide something to the table. I think the approach is spilling over to tomorrow, and Mr. Brophy's considerations are probably quite correct.
Bettina, how does that?
So my only concern is support that Ngāti Whakapura and the iwi present evidence, but just in terms of timing, it seems to me that it would be unfair if Blue Haven gets heard today without the ability to have either seen that evidence or comment on it. So timing wise, in my mind, it would be better if the submitters that are commenting on the zoning go first and that then Blue Haven follows, because then they can address any issues that arise through that evidence, particularly evidence that my experts haven't even seen yet.
No, look, I think that's a discrete issue. I'm very happy for you and your witnesses to provide any supplementary comments after you read evidence and anything that might side and oral evidence. But we'll just round up after they present, and I'll certainly got an opportunity for you to respond to anything.
Oh, that's fine. If that's the opportunity is provided, then that addresses that issue.
Everything else was staying overnight and
No other issues.
yeah, all right. That's great. Well, Kit, I'm just thinking, do you have any other comments on order of things?
No, I think that's the right order. I mean, we'll be flexible if issues come up that people want to comment on. I mean, we're going to be most assisted by getting everyone's opinions on everything, really. So I think it's a general batting order. The only thing I wanted to say is I deeply regret that I'm not in the room with Stephen. I very much enjoyed the last month face-to-face debating things with all of the witnesses that were presenting, and but for a conflagration of domestic issues in this hearing, I'd be there. So I just wanted to express my apologies, and I'll do my best to keep up with everything that's going on.
Right, so as you've seen, there was a slight delay on the audio, seconds, so we'll just take it slow with things. And certainly, as I agree totally with Kit, we're here to hear everyone and really just get the best hearing of the issues there. And please, if anyone's not hearing anyone, including me, because I tend to speak briefly softly, please and just ask people to speak up. We're not sitting in your shoes when you're coming in from the wall. Please do that. All right, so without further ado, we'll hand over to the council. Thank you.
Thank you, sir. Team's already obviously been introduced. The legal submissions that I've filed, the opportunity to read those. Time, and I appreciate that. So just wanted to check you have them and whether or not you've read them.
Yes, I have, I'm sure we'll have.
Sorry, I was on mute then. I've only skimmed them, so I'd be quite grateful if Lauren could take a moment to go through them when the time comes.
Yeah. So what I propose we do is that I'll just start with the legal submissions just to set that legal framework and to highlight some of those key legal issues, and then
Good.
hand over to Mr. Bonas, who has a presentation in the usual form, which summarises the Section 42A report, recommendations, and the evidence that will or has been presented by Mr. P and Ms. Taylor. They each also have just a brief summary statement, speaker notes, to summarise their evidence. Ms. Taylor hasn't provided a statement of evidence, but she's here to confirm her participation in the conferencing for traffic matters, and she just has a couple of comments to make in respect of the evidence that has since been filed by the So I think the background to this is fairly well established. This hearing is obviously in respect of the Blue Haven submission and the Hamlin submission seeking to rezone the sites out at 60 Road and Smart Road. The issues my submissions cover are scope, statutory considerations, zoning as a mechanism to confirm resource consent, and national planning standards. In terms of scope, on page 3 of my submissions, I've outlined there some of the key submission points that were made in Blue Haven's submission. The key being that the general industrial zone is not appropriate for the Blue Haven site, that it would be impracticable to manage Blue Haven's development within any of the zones in the proposed plan. Sub-regional centre zone was sought, or in the alternative, Blue Haven sought to retain the existing industrial D environmental area zone, which is in the cooperative. And Blue Haven also proposed a suite of draft objectives and policies for a proposed new zone or site-specific provisions, and that's set out in table 3 of the submissions. The relief also indicated that such further or other relief or any alternative wording of consequential relief to give effect to the matters raised in this submission. That addresses the submission. The summary that was provided by the council is set out at 2.2. To take that as read. In hearing 1, which was on the objectives and the strategic direction chapters, the issue of the sub-regional centre came up, and at that hearing, Blue Haven presented and sought amendments to the strategic objectives, which effectively were seeking to accommodate Blue Haven's proposed sub-regional centre into the PDP centres hierarchy. At that point, the council officers noted that the relief sought didn't include the types of provisions that would normally be expected for the centre zone, and that was in the reporting of the supervisor. And the panel, of course, sought legal submissions. So those were filed in July. Set out what I think to be the most relevant extracts from those subs, but in 2.4, indicated Ms. Barry Pinchino's submissions, and she submitted that there was sufficient scope to rezone the site, and that any reasonable and consequential iteration planning framework sitting between the parameters of submission and the parameters set by the proposed is within scope. In my submissions, I submitted that there does appear to be scope for the identified activities, but the submission provides little clarity by way of policy guidance, controls, limitations, and standards. And that should such clarity be provided, panel will still need to make its own judgments applying the orthodox reasonably and fairly, and that any alternative or consequential relief must remain within scope. So we were then directed to undertake some pre-hearing caucusing, and the process has been undertaken. There's a pre-hearing meeting and there has been witness conferencing. And this process has resulted in numerous and significant proposed changes to the suite of provisions that were included in that original submission. The joint statement arising from the planning caucusing noted as follows, that Blue Haven and council planners agreed that the consideration of the notified general industrial zone required as the base case option. And the participants at the conference agreed that the general industrial zone is a reasonably practicable alternative. Blue Haven's planner concurred the commercial zone with a precinct plan is a reasonably practicable alternative. And the participants agreed that the commercial zone is an option within the scope of the submission. And the participants also agreed that the proposed special purpose zone is a practicable alternative, but that this approach would require the application of a precinct spatial layer. So the agreed action points arising out of that were that Mr. Brophy would review and provide an updated special purpose zone, and that Mr. Bonus would prepare a full commercial zone chapter. And that's obviously now occurred. And the sub-regional chapter zone proposed is attached to Mr. Brophy's statement, and Mr. Bonus's proposed commercial zone is attached to the 42A report. So in the 42A report, Mr. Bonus recommends that the proposed commercial zone with a precinct overlay be accepted. His recommendation is predicated on the basis of the existing consent and based on the evidence of Mr. Heath and conclusions as to the vulnerability of the city centre. However, paragraph 204, he notes, in the context of the submission request did not contain the implemented consent, I would be recommending that the amending proposal be rejected. In a similar matter, if the panel, upon hearing all of the evidence, concludes that consent should not be given as much weight as I have, the retention of the general industrial zone as notified remains the more appropriate option. So Mr. Batchelor's statement of evidence states that there's little fundamental difference in the proposal, the provisions of the two proposed zones for you, and that both zones recognise and limit the range and scale of activities effectively to comprise the consented environment. He stated that if either of these zones are more appropriate than the general industrial. With respect to the zones options now before you, it's submitted that there are two matters which you must consider. Whether the changes that are now proposed are within scope, and the extent to which the consent is relevant and the weight it should be given. I've set out the relevant legal principles regarding scope, and they're fairly well known and fairly well established, and we have canvassed these in other hearings, so don't propose to go over those. And just jumping straight to paragraph 2.19, I submit that ultimately it's up to the panel to consider whether the amendments now proposed go beyond what was fairly and reasonably raised. The panel should not amend the provision beyond what has been raised in the questions. However, it is entitled to include amendments that an informed and reasonable method, having studied all the submissions, should have appreciated that the council might make. In my submission says, given that the Blue Haven submission opposed the general industrial zoning, sought a new zone, sought site-specific provisions and or alternative relief that was necessary to give effect to the matters raised in its submission, that the scope afforded by the submission is quite good.
Laura, I'll lead off and get but I want to start with a question around the panel minute 13. I think that was issued 3rd day of September, Thursday, 2021.
It's been your birthday.
And I was just reflecting, looking at that, I think the party's done a great job, taken a while, of really embracing that and much as we be anticipated. Do you agree with that?
Absolutely.
The only question I had was when Kate was liaising with us, I suppose, from the Straka to pick this up, made a comment about scope, read it out during this process. If there are any issues with scope, Ms. Wallace and myself can discuss them as part of the hearing process, try to resolve them between us. Now, my first question, two questions arise from that. Have you had a discussion about scope between you and Kate as part of the hearing?
Yeah, sorry.
That's the second question that might help. Are there any material differences you think between you and Kate's position on scope?
Ultimately, no. Submitted there, I think. Case law indicates that can review amendments can land in your commission. What's being sought here is a special purpose zone, notified plan with an industrial zone. So somewhere in between there. An expectation could reasonably held that provisions will land. Now, in saying that, the submission was and is predicated largely on the consented environment as the basis for seeking the zone. So in my submission, where scope is limited, is to ensuring that whatever does happen on the site is similarly constrained by that consent.
And you don't see a legal issue with the fact that we had on submission the broad request, with none of the details filled out. And now we have two totally developed bespoke zone provisions. That certainly wouldn't be the case if this was a pilot. So I'm just trying to get in my mind why the standard of proof in its submission, the plan review might be different to what might. What's the?
Absolutely. And my submission, they do make the point that evidence produced at a hearing can't extend the scope. So scope's scope. You either have it or you don't. Once you do, your evidence needs to be so whilst there are any proposed here, and yes, they do go beyond what was expressly set out in the submission. When you look at it in the round, reasonable themselves. Then looking at the submission, one of the potential outcomes is that in zone. Not applying any legal niceties, submissions that might come to that.
Only thing as far as consented environment, anything further than that is out of scope.
Certainly, that's what the submission and it has a
Your submission.
For this.
No, I'm not asking for your submission. So anything further in what was consented environment is out of scope for us.
That's my
Do you have any questions on scope?
Yeah, I just wanted to touch off on a couple of things. Lauren, you say that the submission was predicated on the land use consent, but of course, the resource consent was still in process and hadn't been granted at the date the decision was made. That's right, isn't it?
Yes. Yes.
And if you look through the relief in the submission, the closest it gets to, I guess, referring to the process that was going on is where it opposes the general industrial zone. And the relief it says is that a new specific zone be created to provide for the commercial and retail development that will be established on site. So I agree there's a link between at least the application and what the relief was being sought. But when it goes into looking at the specific provisions for the new zone, there doesn't seem to be any great reference back to the resource consent. It's a much broader proposition, isn't it?
And that's one of the challenges that the plaintiffs have come across, is trying to shoehorn a resource consent into a zone. It's not an easy task.
Well, I guess that would be a problem if the submission had, by way of relief, said make a zone that replicates resource consent X. But that's not what the submission does. It seeks a broader zone to function as an integrated business activities. So I just wonder whether the resource consent is actually that determinative of the scope of the submission itself. What's your view on that?
I understand the point. Yeah, I understand your point. And I agree that at the time that the submission was made, the consent had not actually even been granted. So the application was in train though, and the application, as I understand it, was solely for transport and traffic matters. The actual land use activities of retail and commercial consent wasn't needed for that part of the development.
Yep.
So,
I mean,
yeah,
there are a range of matters for which consent was required, and we'll get to that because that sort of goes to this notion of the given effect to sort of concept. But I guess putting it back, if for example Blue Haven had not even lodged a resource consent and had sought to promote its aspirations for the site simply by making a submission on the district plan to rezone the property, then wouldn't we be in exactly the same position we are, in that the submission itself is probably not fully formed to that extent? And the resource consent is almost a little bit of a side issue to that. I mean, it's relevant, but it doesn't craft the relief, does it?
I'd accept that.
I mean, to some extent, all that's happened is that in the meantime, the resource consent has been granted, and that fact is now being prayed in aid of the relief sought originally in the submission.
That's correct. Yep, so we have a situation where an application was in train, submission was made on the proposed plan that a zone be created to enable commercial and retail development on the site. Post notification of the plan, the consent's been granted, and now the evidence in support of the submission is that the consent forms part of the existing environment, and therefore the section analysis in 32AA and 42A should refer to that existing environment when it didn't exist at the time the plan was notified.
Yeah, okay. I guess the relevance of this discussion, Lauren, it comes to this difference between Mr. Bonis and Mr. Brophy Mr. Batchelor at the moment, which is what is how flexible, how much wriggle room ought the zone to provide over and above the resource consent to some extent. And I wonder whether that is actually the right question, because if the zone is not actually predicated on the resource consent, but is a broader request for a rezoning for commercial purposes, do we need to be that focused about whether there is scope to go beyond the resource consent terms? See what I mean? Because there's potentially an argument that yes, you can get a zone which replicates the resource consent, but that's it. You don't have scope to go further. But if we read the submission and put the resource consent in its place, then really we've just got again a broader request for a zone and a set of provisions that give effect to it. And the resource consent isn't really a baseline for scope. I mean, would you agree with that?
I would agree with that.
Okay. No further questions. Thanks for that, Lauren. I've got some other questions later, but look, I'll let you keep on with the submissions.
So the next topic was statutory considerations. And I've set out at paragraph 3.1 the matters which influence and which you have to have regard to when making a home. And the well-known process as set out in Colonial Vineyards is attached to the submission for ease of preference. My submission, the key considerations here are that each proposed objective in a district plan is to be evaluated by the extent to which it's the most appropriate way to achieve the purpose of the Act. And then each policy or method is to be examined in regard to its efficiency and effectiveness, and as to whether it's the most appropriate method for achieving the objectives of the district plan. And then in making a rule, the territorial authority must have regard to the actual potential effects on the environment. As I mentioned on before, at 3.4, each party does have the evidential burden of establishing matters of fact, the expert opinion which are advanced by it, and should put forward a proper evidential basis to support. The section here about the NPSUD, and that was canvassed at the hearing 1. Simply make a point that obviously it wasn't enforced at the time the plan was notified. It came into effect just prior to the further submission period. Some further submissions have been received asking that the PDP align with it. And I simply make the point that where scope exists as a result of relief sought in submissions or further submission for changes that will give effect to the NPSUD, then those changes can be made, but any changes outside that will need to be considered as part of the mandatory changes, which Burns already addressed.
We have one question about the associated with definition of that will quite an extensive really it builds his case that there's not really much if you interpret the way we told it. Need to come back.
Yeah, I might come back to you on that.
Thank you. Yep. Do you have anything on the section?
I have a rather, well, it's probably a broader question, and but it does fit into a discussion of the MPSUD. So I guess I think it's a question of planning and law to some extent. I guess the question is this, Lauren. Does the NPSUD, and in particular Objective 3, which requires district plans to enable more businesses to be located in areas of an urban environment in which one or more of the following apply, and then there's a list there, does that objective stand in the way of council's centres-based approach? What's your view on that?
So again, I'd like to talk to Ms. Bonas and Mr. Heath about that.
Okay.
Mr. Bonas has indicated he's covered that off. So that might be a question we could ask
Yep.
him, and then if
Okay.
satisfy your
I-
inquiry, I'm happy to come back to you on that one.
Yeah, okay. Look, if that's something that the chair asked, and I've asked it again, it's simply because he was fading in and out, and I didn't hear the extent of his exchange with you. So I'm sorry about that. I mean, just for full disclosure for participants, I started preparation for this hearing by going right back to the strategic directions hearing and all of the material that we got around UFD. I think the 4 UFD objectives that we've sort of left in abeyance until we come to this end, just so I'm sort of back to where we started the plan to some extent, and so from my perspective, there is an intricate linkage between how the final crafting of those UFD objectives is resolved and what we do here, because there are a couple of pathways, and I guess the one that the specific evidence that we've got in front of us now has, which we didn't have the benefit of last time, is a very much a more focused approach on what this proposal is envisaging, and then ultimately whether that aligns with the strategic objective. But it also begs the question of whether the strategic objective around a centres-based approach is the appropriate one. So I appreciate there'll be lots of discussion about that over the next couple of days, but that's certainly an issue in my mind that I'm quite interested in. Thanks.
Yeah, look, I haven't put a lot of thought towards that, but now that I have that background, I'm happy to have another chat to the team. The position on that.
You can come back to us
In the reply.
reply.
Yeah.
If needed. I just want to double check the comment about us fading in and out. Is that a volume issue, or is that something more than that?
I don't think it's a volume issue. I've got my volume turned up full. I think, Stephen, it's when you start speaking and you're not facing the microphone, it doesn't pick you up until you're sort of halfway through your second sentence. I know it's unfortunate, but it's just, I think it's just about which way your head is facing when you start to trigger the microphone to turn on.
If I could add, it looks also like it's a volume matter. So perhaps towards the end of your sentence, as you soften off a little bit, we do lose you. So the earlier exchange, I only heard about a third of the question from the Commissioner.
Morning, everyone. The hearings assistants have advised that the microphones are in the ceiling today, and that might be causing our problems because we're having the same issues.
Well, I think this is quite a concern for me. I'm wondering, is there a particular way I should be talking? I'm not even sure where the microphones are.
No, those are the microphones that one above you.
Do I have to head back and?
Have to. I'm just wondering whether or not we move your table just even that forward, so then you're actually directly under the mic.
this is the one up here, the round.
Yeah.
That I am
Yeah.
directly under it.
I mean, that's fine, Stephen. I mean, I'm hearing every word you're saying there. I think it's
Okay, I think I
yeah.
can tilt my head and talk to the microphone.
Yep.
Which is going to be a bit uncomfortable.
I think it might help if you stand on your head. That would be helpful.
May I make a better suggestion, and that is maybe there's a roving mic that can be passed around, or a mic per
Or
party group.
I think maybe if I lie on the table.
Yeah.
But seriously, I wonder whether we can just get some IT help, see whether a specific microphone is possible.
Yeah, I have messaged Richie and I'm waiting for his reply. So another issue. So as soon as he's able to.
Given we're at the nitty gritty of things,
Yes.
I wonder whether I just go really slow and speak really loudly and see whether that will solve the issue, and we'll carry on.
Are you okay with me leaving for a few minutes and I can go out?
No, not really. We can look, we'll see how we go for the break. But let's just carry on.
I think if people assume that we're old and deaf, that might help to start with. We'll be able to hear us.
Speak for yourself, Brown. They don't have to assume that for me.
Thank you.
All right, so where were we? I think we're moving on to the next. Zoning as a mechanism to bring resource consent.
As per our discussion before, one of the relevant considerations for the panel is the extent to which the consent is relevant, and if it is relevant, the weight that should be given to it. So the 42A report notes that both the economic joint witness statement, planning joint witness statement, or agreement that the consent now forms part of the existing environment, albeit that the adverse distributional effects are yet to be felt in the city centre. And while it is accepted that the consent has been given effect to, Mr. Bonis doesn't consider there is a duty or obligation on the council to ensure that by virtue of that consent, the site should now be rezoned to provide for and enable. In respect of giving effect to, it's noted that this is a relevant consideration in relation to the test under 125 as to whether or not it lapses. And ordinarily, the question of whether a consent has been given effect to is a question of degree, and the answer varies from case to case. Similarly, as noted in my previous submissions, the terms existing environment and consented baseline, when properly understood, are consent and effects assessment tools. While it's acknowledged that the implementation of consents can be relevant to an evaluation under 31 and 32, it's submitted that the existence of a consent is not a mandatory consideration relevant to the question of submission scope or when considering the merits of different zoning. I referred to a case in my previous submissions where the court acknowledged that a plan must be forward-looking, but also based on the existing environment. And the reference in that case was to the existing environment as a matter of fact and having regard to the planning history for the purposes of section 32. It was not authority for mandatory application of the existing consented environment or lawful environment, considering the merits of the 4.5, a reference to case A King Family Trust. In that case, the King Family Trust appealed against parts of the Hamilton City District Plan in relation to a 1.7 block owned by it. The trust had consent to establish a supermarket on the site. It was zoned industrial, but the trust wanted to undertake commercial activity properties on it and to complement the supermarket with additional retail and office developments. The trust proposed a tailor-made overlay with a new objective and policies and rules to make it easier for it to achieve its goals and to meet what it said was an unmet need for such activities in the nearby western suburbs. The Environment Court got some extracts there, held as follows, about the relevant pieces, that the unimplemented supermarket's consent has not reached the stage where it could be considered as a permitted baseline, which in any event is not a relevant consideration when considering a plan change. We do not agree that it should be used as a springboard for further commercial activities, or the fact that the consent was granted for it under a more permissive planning regime means it should be given any particular weight when assessing which is appropriate. Even if there proved to be a shortage of zoned retail capacity, and there was no evidence to make that finding, the appellant did not adequately consider the options for meeting that demand. The court concluded that they should not lightly set aside the new approach to the allegation of business and commercial centres in the proposed district plan, as that approach had been subject to considerable progress through obviously the planning processes that led to it. And then the court's conclusion was, there is also the question of whether the site would be the best option for a new commercial centre. The fact that the site fronts onto the state highway is problematic. While the evidence established that a supermarket was likely to be the largest generator of traffic, and despite the fact there were some solutions to it, it begs the question of whether or not at this stage it's appropriate that a new commercial centre that does not neatly fit within the commercial centre's hierarchy established under the plan should be included. The evidence was not compelling enough for this to be an appropriate outcome. And finally, that when considering the law that applies for plan reviews, we find that the council's proposed zoning and provisions for the site are the most appropriate way to achieve the objectives. We are not persuaded that the proposed overlay provisions would be effective. So it's submitted that this case is reasonably similar to the rezoning requests that we're this hearing. And further, that while there be benefits to Blue Haven to create a new zone to provide a greater flexibility and to local residents and indeed the district affected, the panel must be satisfied that these benefits outweigh the strategic objectives of the. And the question noted by the environment in that case applies equally here. Is it appropriate for a new commercial centre that does not neatly fit within the commercial centre's hierarchy established under PPP to be included in the plan?
So Lauren, I have a question about that paragraph 180 of the plan on King Family Trust.
Yes.
It's really about the most appropriate way to achieve the objectives of the proposed plan, where the council's sitting. My understanding is that the council now moved, Mr. Bonus has moved away from recommending to us an industrial zone and is promoting a commercial zone, quite different to what was proposed plan. Is that now the council's overall position?
Mr. Bonus's position is summarised earlier in this mission.
4.2.
2.11. That the commercial zone with the precinct overlay be accepted, but that's predicated on the basis of the existing consent. And he says if the context of this submission does not contain the implemented consent, then I would be recommending that we not propose to reject it. and that if upon hearing all of the evidence, the panel concludes that consent should not be given as much weight as Mr. Bonus has given it, the retention of the general industrial zone as noted by the
So what is in terms of if council's position, as I understand it, based on Mr. Bonus's, is that the commercial zone is now proposed providing greater heights and the resource consent application is granted. It would be appropriate for us to go back to the general industrial.
We've got to the situation because a submission was made on the plan that the site be rezoned. Council's position was at the strategic directions hearing that it didn't consider that the site should be a centre, and that very firmly remains its position. As a result of the pre-hearing process, discussions were had as to whether or not a different zone might be more appropriate given the fact that the site is going to be developed. The council undertook to hear what it considered could be an alternative option. Its position is that a special purpose centre zone, but ultimately if the consent is not to be given weight or is not taken as part of the consideration, then the council's position remains.
Okay. Any
Yeah,
questions on this
The
topic?
section, yeah, I've got a few actually.
Yep.
I'll start with the given effect to notion. And I guess the first question there is, I think you've correctly pointed out this phrase given effect to is quite, well, it's used in a couple of ways in the Act. One is in the way in which lower order documents need to respect higher order documents. In this particular case, so it's being used in the sense of section 125, which is essentially that the consent has not lapsed, i.e. and thus will not lapse. So that's the I guess the quite discrete meaning of that phrase. I just wanted to get your view on whether you think the threshold for it not lapsing is actually as absolute as everyone seems to have accepted. And I say this by reference to a decision of the Environment Court last year, Turner v. Barrett, NZEN v. C043, where the judge in that case say property was to be built on with a resource consent. A whole lot of earthworks and various things had been done on the site. And it was argued that the consent had been given effect to because of that. Judge Kirkpatrick looked at it and said, well, the only activities or uses of land that the resource consent authorized were the erection of a building within an airfield height control. And because that land use had not in any way been given effect to or even undertaken, and all of the other earthworks were all preparatory and otherwise uncontrolled or unauthorized by the resource consent because they were permitted, it meant that in fact, notwithstanding the work on the site, the consent had not been given effect to. So I just wanted to make sure everyone was aware of that decision. And I think it will involve an analysis of the specific land uses for which consent was required and granted, and an evaluation of whether they have in fact been given effect to, rather than the fact that a whole lot of earthworks have been done on site. So has anyone contemplated the implications of that decision in the context of this particular resource consent?
Not on the council's team, I can't speak for anyone else.
Okay, all right. Well, I think I just raise it because it may be that the land, well, it may be that consent was required for earthworks. I think there was a mention of a requirement to undertake some earthworks close to a significant site, but I don't know whether generally there was a resource consent required for the earthworks and concrete grinding and all of that sort of stuff. I'd just be interested because it does potentially put a wrinkle in the conclusion that the consent has been given effect to. So I guess that's just one thing that was playing on my mind. The other one.
Sorry.
Yep.
Can I just quickly respond to that? One of the complicating factors in this case is that the resource consent includes an advice note, which says that if earthworks are commenced, then the consent has been given effect to. Obviously, the advice notes don't necessarily have legal effect, but certainly that fact has influenced the position.
Okay, all right.
Experts have landed on. It is an interesting legal question, and as is the question of whether given effect to under 125 has the same meaning as likely to be implemented in the.
Yeah, well, I think that's where where the conversation sort of naturally and probably more appropriately lands is in this notion of the future environment and the Hawthorne sort of R.J. Davison construct that the future environment includes unimplemented resource consents that are likely to be implemented. I think that's the phrase, or is it likely to be given effect to? So from I guess likely to be implemented. So it's a resource consent that's unimplemented but is likely to be implemented, and that's a question of fact, if I remember rightly. So notwithstanding that works may have progressed to a point where it will no longer lapse, that doesn't necessarily mean that it ought to form part of a future environment unless we're satisfied that it's likely to be implemented. Is that a bit?
That's my understanding.
Okay, so that's where the evidence of Mr. York becomes quite critical to some extent. I mean, and on the face of Mr. York's evidence, that the considerable expenditure in terms of earthworks plus acquisition of the site, but in the context of, I think the figure he used of a $200 million investment, it's probably not more than 10% of the expenditure to date. So, I mean, we're not deciding whether the consent's lapsed or whatever. I think it's up to us to look at his evidence and say, is there a real likelihood that this consent will be given effect to? I mean, fully implemented to that extent. So that's, I can't hear anything, sorry.
Did you want me to comment when he asked about that issue now, or shall I leave it till mine?
I'd rather you leave it until your presentation. Yeah. Yeah. So that was something just about that's sort of been playing on my mind. I'm really grateful you dug out the A and A King Family Trust case, because I think you're right, it's quite analogous. I guess there are two bits of that I wanted to just talk to you about. The first one is that presumably, well, you'd accept that a factor that's, there are two factors that are different in this case. One is we have the MPSUD breathing down our neck as another statutory direction. And the other is that we've also in a position where, even though there are proposed policies around a commercial centres hierarchy, that overall objective itself is still up for debate. So we don't have a situation which presumably applied in this case where there were a settled set of objectives and policies for a centres-based hierarchy. What we have here is a contest at that higher order level as well as at the lower order level. So do you think those are relevant factors that might make that case distinguishable? And if so, what ought we to do with them?
think those are relevant distinguishing features. In terms of the MPSUD, Mr. Bonis addresses the relevance and the application of that. In terms of the unsettled nature of the strategic objectives, Council's position is that it continues to support and argue for a centres hierarchy.
Yep.
And that has come about from a number of years of strategic planning. And the recommended zone put forward by the council today is a commercial zone, which the submission is that it shouldn't form part of the centres hierarchy. So to the extent that the centres hierarchy is relevant here, well, we say that the extent that it's relevant here is rather limited.
Okay.
The mission of the council is that it shouldn't be part of the hierarchy.
I mean, the key question really, hence why I went back to the strategic objectives chapter when preparing for these days, is first of all, ought we to resolve whether that objective is the most appropriate way for the council to achieve its functions and the purpose of the act. And if it is the most appropriate, then to some extent that sets in place a few parameters about how far or what ought to come out at the area specific level. Would you agree with that?
I do agree with that. And it's something I'm not sure that there's possibly this should have been the subject of some pre-hearing directions, because I'm not sure that the evidence that's before you is on point in relation to whether or not the strategic direction objective is the most appropriate. The evidence that's before you today is centred on the appropriateness or otherwise of rezoning.
I mean, to some extent, we have all of the evidence that was presented last time around on that question. So we're not bereft of evidence in that regard. I guess the taking an integrated approach to this, I was intending to ask Mr. Bonis his view about those strategic objectives, but he's very carefully circumscribed or curtailed the scope of his evidence to be focused on the very point you just made, Lauren. And it is going to be something that I do want to test, because we've got very different authors for the strategic objectives. Mr. Bonis wasn't involved in those. And it just seems to me we are going to hold both of these provisions of the plan in the same place at the same time to be able to come to a considered view on them.
Yes.
I mean, for example, I'll ask Mr. Bonis, do you think the centres hierarchy that's currently encapsulated within UFD 16, 17 and 18 can survive the inclusion of an additional zone that specifically recognises commercial activity of the scale proposed at this location? And hopefully he will have thought about it and have an answer for me.
Yeah.
That's a good, yeah, certainly this discussion is very important. In my mind as a decision maker, I would think we do need to set all the strategic objectives. And that's the way we've set up our deliberations. If you don't ask the same question of Mr. Batchelor, that is a very experienced planner, I think I will as well. So Craig, in terms of a heads up, that's important to us as well, given the scope of your evidence, comparing it to the Waikato and Pinky circumstances. To carry on,
No, those I mean, those were the only things I really wanted to lay out there, and I appreciate Council for the first party does get the discomfort of everything that's in the panel's mind bubbling up after preparing. So these are issues that are front of mind, and we'll have a conversation with everyone about throughout the next 2 days. So I'm just throwing them out there, Lauren, but I appreciate your answers in that regard. Thanks.
No, that's fine. And Mr. Bonis and Mr. Heath both speak to, as I understand it, the key issues regarding directions chapter were one, whether there should be a hierarchy or a network.
Yeah.
And then two, whether the site should be incorporated within either of those. So I believe Mr. Heath is available and ready and willing to speak to the issue of networks versus hierarchies. And then both witnesses can speak to the issue of whether or not it's appropriate that this be zoned and incorporated as a centre.
Yep. Oh, look,
Sorry, you certainly have evidence from Mr. Heath already on that, but you want to confirm, but we do have two different planning witnesses for the council. So that's a clear. You've got one more section, I think.
Yeah, but the
Laura.
last section is just in relation to the zone framework standard and the NPS. Can I just touch on the issue of whether or not standard, whether there's any firm direction one way or the other as to whether this should be a special purpose zone or a commercial zone. The three questions that are posed, which Mr. Batchelor had in his statement of evidence around whether or not a special purpose zone must can be created, are set out at 5.1. Mr. Batchelor's evidence is that considers the commercial zone as proposed by Mr. Bonis is not appropriate. It's only practical on the basis that it's modified through the addition of a precinct, make it solely applicable to the Blue Haven site. I just simply note that the planners will all agree that a special purpose zone approach would also require an application of precinct spatial layer. So both zones like suffer from the same problem or fix. It is noted though that the guidance does state that additional special purpose zones should not be used to provide for variations of zones already contained in the framework, e.g. additional commercial and mixed-use zones. And it does state that in these cases, other spatial layers such as precincts should be used. So the commercial zone description as it applies to areas used predominantly for a range of commercial and community activities, and it's submitted that this is entirely in accordance with what's being proposed on the site, and that it's not impractical to manage the proposed land use activities by way of a precinct overlay. Ultimately, I note that Mr. Batchelor's opinion is that there should be no impediment to the zone options of either a special purpose or commercial zone, and that either is more appropriate for general industrial zone. So the submitter appears to accept that the commercial zone is one. In relation to the special purpose zone provisions proposed by Mr. Brophy, do have some hesitation around how that framework will work, and how it will ensure sites on that activities on the site are undertaken in a manner consistent with consent. I just note that the road upgrade works rule provides that activity, road upgrade works, are a restricted discretionary activity, and then the standard in relation to that is where any development up to 13,000 square meters and infrastructure, it doesn't quite make sense, and it doesn't fit within the framework of the plan. It's not clear what's being controlled by this rule. Is it the road upgrade works or is it the commercial service activities? And it's not clear either how it will ensure that the road upgrade works will be undertaken prior to the activities actually occurring. And then Finally, I just note that Mr. Heath's evidence is that the implementation of the consent will have significant and enduring adverse economic impacts on the city centre once it starts trading. The evidence of Mr. Bonus and Mr. Heath is that if the Blue Haven consent is to be accounted for in terms of the zoned framework, it should not be used as a springboard for commercial activity, nor the diversification or increase of or where such would duplicate the role of function. It's therefore submitted that if the panel is minded to rezone the site, the range and scale of activities allowed should be constrained and confined to what's
Thank you. Questions on that section? Hit the you.
Yeah, I think I understand there is a debate about whether direction 3 is met, but I think where everyone's landed is that it probably doesn't matter what you call it, as long as it does what everyone wants to some extent. Is that fair enough?
That's fair enough.
Yeah.
I think the key distinguishing feature is whether or not it's a centre.
Sorry, say that again. I missed it.
I think the key distinguishing feature between the two parties is whether or not it should be a centre.
Yes. Yes.
But ultimately, the provisions will fit whether they are a special purpose zone or whether they are a commercial zone. And
Yeah.
name it whatever you like. It
Yep.
could be a special purpose commercial zone.
Yep.
For example.
What about something completely crazy like an industrial zone with a precinct overlay that allowed commercial activities? Or would that cause planners to have conniptions?
I'm just looking at the planners in the room. They're laughing.
I don't know if that's a good thing.
It's nervous.
Nervous laugh. No. All right. No. Let's not be that provocative this early in the hearing. Okay. No, that was it. Thanks. Thanks, Lauren.
Follow-up question for me is, if it's just all in our name, won't the Blue Haven development operate as some form of centre, whether you call it a centre or not? Same basis.
So that's the position of Blue Haven, that centre's a centre. I would submit that the issue here is what that means in terms of. So for centres, there are different sections and different. For the Blue Haven Centre to take the benefit of the protections which have been crafted to ensure that Centre City remains a viable prospect. That's a matter that the council is concerned with.
Summary. Right. We're now moving on to the.
So we'll now call Mr.
Yes,
Mr.
sir.
Bonus.
I haven't done this before, so there's a presentation, I understand. To assist with the presentation, I've asked Mr. Heath and Ms. Taylor to provide effectively a short summary statement to assist, I guess, and thank goodness with the hearing difficulties, with what we're going to traverse. To be helpful. Within mine as well, I've referenced through to where that information has been found. Okay, next slide, please. So in terms of the summary which everyone's got, I'll simply take section 1, the introduction, as read, effectively just reconfirms who I am and abidance by the code of conduct, essentially the matters the team's going to traverse this morning. In terms of the next slide.
Yeah, I'm just
one to,
I'll just read through it. Yes, let's move it through.
Hold, I think the thing is we get it up on screen so everyone else can see it. Is that right?
yeah, it's, I'm not able to use.
But look, I'm wondering if we should take it really and where Christine put this out. And also, Christine, if there's any assistance from the IT people about getting better audio in this room, I think it would be most helpful. So,
Just to give you an update on that, yeah, I had Richie in and he said that he'll come back in the break. And I've asked Julie to go online and see if we can do something. I did ask if there was possibly a handheld mic, even just sit over the side of you. We'll see what we can do.
okay, can I just confirm with the wall? Is it just a struggle with my audio or is it everyone that's speaking?
It's everyone when the volume of their projection drops below a certain threshold.
Okay. So we have had speakers calling us before. But I think let's take a break until 10:45, see what can be done.
To give you an idea, just at the very end of what you just said, it was fading away. Before then, we could hear you quite clearly. So the tail off to the end of a sentence is where we start to lose you if your volume is dropping a little bit.
Okay. Thank you everyone for the Chairman. I hope you all had good lunch. I do have one I'll talk to the team about before we move on with Mr. Thomas. Hamish, I'm just been thinking tomorrow, if you're looking in that we are dealing with Road Devon tomorrow at 9 o'clock. And we've asked Commissioner McMahon to join us because he's involved in dealing with that matter. And because you have similar issues to the next door piece of land, whether we might be better just to hear from you tomorrow morning, and that might give you a chance to go and have a bit of a rest with your COVID this afternoon. But I thought I'd give you that option because that might work better if you thought it was okay.
Yeah, that would probably seem appropriate.
Yes.
Yeah, would that be first thing tomorrow morning?
Yes, at 9 o'clock. So we're going to deal with the Road Devon issue, and I think you're happy to give us your or answer questions for us at the same time.
Yeah.
Because
Yep.
of the similarities, I think, between those two areas, your clients and the site.
Yeah.
To the north.
Yep. No, that would seem fine. Yeah, happy to do that.
Okay. And that solves the other issue we've got, that Mr. Campbell's on a plane this afternoon at 5, so we can certainly make sure he's sort of through this afternoon. Thank you. So thank you, Hamish. We'll just reschedule that. You can listen in at your will and drop out at your will.
Yep, no problem. Thanks very much.
Thank you. Right. I think we're now ready to ask questions of you, Matt.
Also,
And in time on tradition, I think Commissioner Littlejohn will kick off.
If there's anything left to finish.
I don't know if I should take that as a compliment or not. Right. My first observation, Mr. Bonis, is I've never had the experience of dealing with you historically. It's probably because we've, by the look of it, practiced at different ends of the country. But I do want to acknowledge the work you put into the 42A report on this. It was very helpful. And certainly assisted to formulate a lot of my thinking around what we've got to discuss this week. So just wanted to acknowledge that. Was quite appreciative. I want to start really at the top. In your notes, you talk about, and I haven't got your presentation on screen. It's your paragraph 3.13 in your speaking notes, and it was really this point that is still in the back of my mind about what the higher order objectives say. I guess the first question is, in terms of this debate between a hierarchy and a network, do you think it's significant as to what we call it? I just say that because, from my understanding of the words, a hierarchy is effectively a network in which some parts of the network are given greater primacy than others. So, what's gained or lost by using the term network from your perspective?
I think the counterfactual, I think, sir, is that the term network can be utilised, providing that there is considerably more detail, in my view, in the strategic directions about what is the role and function of each of the aspects in whatever the network that you're left with. So it's very, very clear how that integrates in terms of spatial form, specifically sort of your residential intensifications and integration. And also what the scale and the functional and social amenity is that you're expecting in each of those categories of centre. It's not in a hierarchy.
Okay.
But I guess, sir, in simplistic terms and based on my experience, most district plans use hierarchy. It's a reasonably well-held view as to establishing the primacy or the descending order of these bits of urban form and what then flows on around them. So is it substantial? No, providing that there's a lot of description otherwise.
Okay.
But I think it has a place.
Okay. So, I mean, your observation there is trite, really. I mean, it's because most of our towns and cities have evolved on the old British model of here's the main street, that's where everyone goes, and then everything sort of evolves over time outwards. So you generally do end up with a main area of the city or the town, and the bigger you get, the bigger cities are of a different sort of scale altogether, really. And I can't see anything in the NPSUD which sort of suggests you need to have a network approach or a hierarchy approach, just that whatever urban areas you have, they have to be well functioning. So, I mean, we're not going to get in trouble from the minister if, for example, we do continue with a hierarchy based on a centres-based approach in this plan, are we?
I agree, sir. And there's nothing in the NPS that would move you one way or another.
So, I'm just going to follow up. What about the compact form requirements?
There is no compact form requirement in the NPSUD.
Okay.
Well, that's right, isn't it? Yeah.
Just have to check.
I couldn't see it. I know compact came about through the Auckland plan because Auckland had got way too big for its boots and they wanted to make it more compact.
No, it's well functioning urban environment.
Well functioning.
Yeah. And so whether,
Compact was used within the New Plymouth proposed strategic directions, yes.
yeah, as it has been in a number of other town centres, because I guess compactness is a, I guess it's a surrogate for efficiency, you know, reduced distance of travel, everything in one place so that it's easier to access. Is that, I mean, that's how I see it. Is that how you see it?
My non-economic understanding of that as well.
Yeah, yeah, okay.
Intensification speaks to efficiency.
Coming then, if I can, to these unresolved UFD objectives, and if I understand your evidence correct, your advice to us would be that we don't need to alter one word of these objectives if we adopt the commercial zone plus precinct approach that you're recommending. It can sit and live and exist within the plan.
And align within those, yes, sir. That's correct.
Okay. So, I mean, so even if you were to look at UFD 17.3, I mean, UFD 17 is where the hierarchy is set out. And we go down the list there of the city centre being the primary. We then have a reference to Waitara and Inglewood. And then we have these things called local centres made up of rural service centres, village centres, suburban shopping centres and neighbourhood shops. So you wouldn't be recommending to us that we would modify 3 in some way to refer to whatever ends up at the Blue Haven site, that we should just let it exist as its own area specific set of provisions, but don't recognise it in any way in the centres based approach.
My advice, as identified in the summary, is once it's allocated that sort of centres terminology, there are consequences that flow on from that in terms of higher order documents and also in terms of the district plan. Treating it as just a commercial zone, the equivalent of a large format retail zone, takes that impetus and those policy directions away to a large extent. And it's not something that can't be revisited in time. I think the thing that, and it may emanate in my evidence, there's this ultimate question of what is this thing? Because the consent is very retail centric. There's no public space, there's no public agencies, there's no council investment. And until this thing actually develops, lands, grows and moves, it's very hard to provide any direction to yourselves as how does it fit in terms of spatial form. One of the things that kept occurring to me as I was drafting my evidence is almost tail wagging the dog. It's very difficult. Once we decide that there's a consent and the consent has validity, and we have to come up with a zone to try and recognise that to provide some forward planning, how do we then fit it into the framework? Because the framework then has to evolve to accept this thing. And it's a very difficult, it's been a very difficult prospect to put forward. So, sorry, sir, long-winded question. Don't call it a centre, and yes, the UFD provisions can stand. Whether there's additional polishing that's come to the panel through other hearings, that's the panel to decide.
The UD strategic objectives,
The UFD 16, 17, 18 and 19, which I understand weren't part of minute 9. Oh, yes.
Actually,
Okay, that's good. Sorry, you had a very long report and I made very copious notes. So I'm just working through now to see which ones. Yeah, paragraph 231 of your report, you make a reference to section 18 capital A B2 of the Act, and I must say I hadn't come across that as something that we needed to think about, but can you just explain to me what you're saying there? Actually, the first question I have is, what is that section? I don't think I've ever seen it referred to in all my years. Section.
It was surviving the Christchurch IHP process. It was something that was in the statement of expectations and subsequently flowed into the RMA. It was essentially about planners writing cogent provisions where there was clarity so that they were easily to understand. And all Section 18A, sorry, AB 2 does is basically say that the provisions by all of us should be worded in a way that's clear and concise. And after being beaten repeatedly through that process, it's always something that's front of mind when I try and draft something.
All right, okay, that makes sense. Now it requires decision makers to take all practical to apply new procedural principles. Okay, all right. Goodness, just goes to show how.
After identifying, I apologise for the provisions that I've recommended.
Yeah, well, I was gonna say, but you know, it is what it is to some extent, and you know, they're not the most complicated provisions I've ever seen in a district plan. So I don't know if that gives us comfort or not, but just going through some sort of quite menial things. Your paragraph 275, have you got that there? And you say that you don't consider that the overview extends to referencing the existing consent for the site, nor extensive detail as to the wider urban or cultural landscape. Now, I mean, at the moment, there's a vast difference. Well, I wouldn't say, yeah, probably difference between your suggested overview statement and Mr. Brophy's suggested overview statement. The one point that is, I guess I wanted to point to is whether or why you don't think that we ought not to be completely upfront and explain in the overview that the zone is the codification in a plan to some extent of a resource consent that was granted. Why wouldn't we say that if that's what in fact we are doing?
It's one that I spent a bit of time on, and ultimately the conclusion that I reached is not many plans provide an overview statement. They're contextually useful, and they're certainly there to provide, in my view, I guess, a forward-looking vision of what the zone is supposed to achieve. And I guess the zone is clearly, from an evaluative in Section 32 AA context, critical to I think the recommendations that have been provided. But I don't know that incorporating or referencing that within a zone overview is necessary. I think once the decision is made and Section 32 AA records it, providing that in the overview, in my view, is unnecessary.
Okay.
It's not something that I'd die on a hill for the survey.
Well, that's fair enough. That's fair enough. Your answer there. Right. Before I want to take a little bit of time just to go through where you and Mr. Brophy, in terms of the machinery, are in sort of different spaces and have a chat to you about that. But I guess the first thing, the big issue that I got to the end of your evidence, and I was still left wondering why you were recommending a zone change. I have to say, and I appreciate that you've been very careful in saying that. But you know, if we gave the consent different weight, then there might be a different outcome. So I guess I really want to try and hone in on the specific reasons for why you think the consent ought to be given weight and the weight that you have given it.
If I can turn you to paragraphs 219 and 220 of my evidence, outlines, I guess, in simplistic terms, that recommendation. Ultimately, it comes down to, this is not an unsubstantial block of land at 7.4 hectares. Whilst there's a resource consent, my experience of larger similar centres that have gone through a consenting exercise is that ultimately, once you do detailed design and tenancy mix and everything else, there's invariably changes that need to be applied for under Section 127. Because it's such a large consent and such a large block of land, the GIS zone has notified extremely prescriptive and restrictive policy settings around avoiding retail activities. So in effect, my recommendation to you, once I'd accepted that the cost was sunk, was to effectively create something that conflicted within itself, which I spent considerable time sort of contemplating and trying to work through, and also looking at whether or not other zones were more appropriate. And it was finally balanced, and it really does come down to this weighting of the consent. But in the end, I've given it considerable weighting. And as I've identified, if a lesser weighting is appropriate, especially within that context of my identifying that it's not determinative in terms of ultimately we've got to achieve sustainable management under the Act, then the GIS remains the more appropriate until this thing plays out. It doesn't stop us from revisiting it under the next plan review or through a privately initiated plan change. Once there's more on the ground and we actually understand what its effects are, what its mix is. Yeah, that's pretty much the conclusion that I reached in terms of saying, well, look, could it be a GIS? And if it's a GIS with a precinct, we end up in the same space. We're effectively creating an inconsistency within the zone provisions themselves. So ultimately, it needs to be called something else if we're moving forward. And then, as I've tried to do, codify that within the consent.
Yeah, I mean, you weren't. There's a certain parallel here with a lot of the discussions we've had over the last month with particularly landowners on the edge of the city who have loaned land that's been zoned rural production. And the blocks are of a size or of a topography that, you know, make it pretty difficult to earn a productive rural living off the block. And so their proposition to us has been, my land doesn't fit within the zone description, therefore you ought to give it a description and a zone which better suits what it's good for, and that's rural living or in some instances residential. And one of the conversations we had was that if we were to effectively do that, we'd sort of be obliged to draft a district plan that mirrored the world as it was, rather than what the plan might want it to be. And I must say I was a bit concerned initially at this when it came to the Blue Haven site, because we are essentially being asked to paint a picture based on an existing proposition that on the face of it is not consistent with the plan. And sort of I mean, I've just sort of made me nervous, I have to say. I mean, the whole point of plan making is to paint a picture for the future, not to simply just replicate what's there, because otherwise you'd be allowing the past to continually place a stranglehold on the future. And I must. You were going to say something, sorry.
So I don't disagree, sir. Hence it came back to that sort of tail wagging the dog issue, especially around the consistency with plan provisions. Carefully marked out that, you know, there are, in my view, considerable tensions with where the plan is hoping to go in the future. And the issue really is, if the plan is to be forward-looking, and we have this consent, and under 125, you know, and the consideration of the environment in terms of the plan frameworking that we have to look at, what do I do with it and where does it go?
Yeah.
And if it was a smaller site or a number of cumulative sites, we'd be having a far different discussion, and probably a shorter one, because I'd be recommending that we hold the line. But this is not insubstantial. And if it plays out as per the consent, there are considerable effects that will land as a consequence. And how's the plan in terms of being forward-looking to deal with those, to leave it gives? In my view, we're essentially leaving those strands hanging, or we're creating, as I said before, that something that's largely incompatible between what the GIS is set out to achieve. You're almost impacting on the integrity of the GIS zone straight away.
Well, that in itself, yeah, again creates a really awkward situation. I mean, for example, let's assume that stage 2 got away of the development. The site was retained as general industrial. Yes, a variation to the consent could be conceived of as a discretionary activity if it was within scope. Potentially, though, it would be that the argument in a consenting framework would constantly be, you're not consistent with the objectives and policies, but the applicant would be saying, but look, I'm already here. And it would just create a series of future arguments and potentially irreconcilable planning debates in a situation where I think, and this is one of the assumptions I've made, is that a lot of that can be avoided by essentially bringing it within the tent, so to speak, albeit in a limited manner. And that in itself is something to be looked and aspired to, because it creates greater efficiency and effectiveness for all participants.
And that's a conclusion that I've reached with a commercial zone recommendation.
Yeah.
You can do it. It's as I've identified, I think several times in my evidence, there is no optimal planning solution. In fact, by 25 years, this is probably one that I've struggled with the most. It's a shame it's my first foray into new planning for quite some time. But there's no easy answers, and you're left with strands, or you're left with inconsistencies in terms of Section 32AA as to how this sits or confronts the respective objectives that you need to consider in that wider context. But the corollary of leaving it as general industrial zone just leaves these strands hanging. It isn't moving us forward, and it doesn't provide integrity in terms of the planning framework. So there's almost this, how do we recognise it? How do we provide for it? And if the panel agrees with the council experts, how do we constrain it and then limit it so it doesn't unpick as best as we can the remaining framework that the council and the community have said they want within the district plan? It's an ugly solution to a complex issue.
Okay. No, I appreciate that. It really is the heart of the issue to some extent. If I could, have you got Mr. Brophy's statement of evidence in front of you?
Yes, I have.
Now I just need to do the same. Okay. Now, if we go to paragraph 90 of Jeremy's evidence, he's endeavoured to set out a comparative table between him and you, I think. Is that what we're supposed to? So table 1, we've got area A, and then table 2, we've got the other areas. So paragraph 90, page 30, yeah. So there's this traffic light table concept here, which enables us to see where the differences are. And to some extent, this sort of segues from our last discussion, and indeed some of the matters I talked about with Mr. Heath about what's the appropriate level of scrutiny to go down in terms of activity status. And I use that phrase because that's how the High Court has referred to activity status as under the Act, with non-complying being the status that means it's an activity that deserves the greatest scrutiny. Discretionary, not so much. Restricted discretionary is scrutinised within certain limits. Controlled, you just have to worry about conditions, and permitted, we've already done the scrutinising because it's in the plan as permitted. So if I go down the list there, can you explain to me why there is a difference in terms of table 1, why, in terms of the commercial service activity, what's the distinction there? Why is one restricted discretionary and one permitted? Because that seems quite a contrast. Does it have to do with the traffic rule that and the traffic works that need to be done?
If I may, sir, I don't actually think, and Mr. Brophy will be able to confirm this, the provisions are actually identical. They're both restricted discretionary on area A, the commercial service activities, subject to the infrastructure improvements going in place. Matters of discretion are limited solely to the construction works. So my reading of Mr. Brophy's rule set in mind is that essentially they're the same as restricted discretion. And it really is just about making sure, as Ms. Taylor identified, and I think the Transport Joint Witness Statement, that the infrastructure upgrades are in place before those works occur. I don't
Okay. Or I might have been I might have missed something there.
No. It's how Mr. Brophy's coloured that table.
Well, that's right.
Okay.
Okay. So what this means is that So this, it doesn't mean that commercial service activities per se need to be reconsented. It means that before any can occur, these works, a resource consent needs to be sought that puts in place these roadworks, but the matters of discretion are solely limited to those matters. That's how it's supposed to work. Okay. And that's because that's the most effective way to make sure the works occur, other than by way of a standard on a permitted activity, presumably.
Yes, and there was, I think the works themselves are specified within the rule.
Yeah.
And they link back directly to what the resource consent requirements were. I think it was condition 6.
So we're sort of taking the view that, for example, and it would be possible in the event that a zone became operative, we need to contemplate the fact that potentially the resource consent is surrendered and then the zone provisions become the sole construct for managing activities on the site. Is that the way we've sort of approached it?
That would be preferable, sir, but I don't think there's been any discussion at all as to whether or not the consent would be surrendered or otherwise. That's a question for legal counsel for BCL.
All right, I just might be interested to know whether we perceive that this rule requiring the roadworks to occur in any way might conflict with the resource consent, but that's something hopefully we can come to. So if I just then go back to table 1, that green should be orange, basically. Okay.
That's Mr. Brophy will be able to clarify it as this table, but that would be
Clarify now, like.
What did he say? Sorry.
We'll see what.
Yep.
See Jeremy's ready to clarify or not.
Yeah. Okay. Cool.
Yep. So the Blue Haven provisions have 2 parts to them. So the first part, I agree, is the same as Mr. Bonis's, in that we have a restricted discretionary activity to implement the roading upgrades. Once they are done, that particular rule falls away, and commercial service activity would then be a permitted activity. So that's the point of difference, I guess. So my table kind of looks at a future outcome, assuming the roading upgrades are complete.
Oh, I see.
So yeah, could have been a wee bit more clear there in terms of the labelling on the table.
Okay. So then,
and the table after that works in the same way.
Yeah. Okay. All right. So yeah. Okay. I see. So then, just going down between the commercial plus and the special purpose zone, you're all agreed on discretionary status for those activities. In terms of, so this is all up in area A, isn't it? This is the top platform. I remember that. Yeah. And then everything else you're on all fours with. Any particular reason why the difference between discretionary and non-complying for large format retail on in area A? Mr. Bonis?
For me, it was the evidence of Mr. Heath as to the threshold of what was consented and those costs being realised in the central city. Area A, as consented for, was building supply outlet, which is extended to sort of commercial service activities. Mr. Heath's evidence is commercial service activities don't have distributional effects. I would want to see anything that's such a substantial change from effectively trade suppliers to large format retail. The zone would turn its face away from that to a degree.
Okay. Maybe I misunderstood Mr. Heath. I got the sense he wasn't so concerned with large format retail, or is it just trade supply? Just trade supply.
Just trade supply.
All right. Where does trade supply sit in the nesting table for commercial service activity? Is it a form of retail or not? I'll find it.
So commercial activities branches down to commercial service activities, which then branches down to vehicle sales, hire services, farming, trade and building supplies, hardware, service stations, and fast food drive-through, which I think the last one was added through a recommendation. To the
Okay. All right, that's
so
good.
Commercial service activities are quite broad.
Yeah, okay. All right, I understand that now. So then we get down into table 2. I note the difference. This is post completion of works. So I got that. That's good. Then really we've got 3. Yeah. What I want to talk about then is, because it's not captured in the table, is really the default status of not complying with the permitted standards for general retail, cinema, business service, commercial service activity, and visitor accommodation. This is where there's a difference between you two, isn't there? Mr. Brophy goes to restricted discretionary with a series of criteria, and do you default to full discretionary?
Discretionary.
And we've got Mr. Campbell saying that for those that might have distributional effects, they shouldn't in fact default to non-complying. Is that right?
And I had a quick read through Ms. Mako's evidence, and she suggests the same.
Okay. All right, so it comes down to that default status for those activities and whether they can be crafted by way of. Have you spent any time looking at Mr. Brophy's matters of discretion, the restricted criteria for those default activities?
Very, very briefly.
All right.
But not to the point where I'd change my position that a full discretionary status at a minimum was the norm.
Okay, so from your perspective, default, MB, default should remain discretionary. Okay. You see right at the top of page 32 of Mr. Brophy's evidence here, I suspect it's because the way the plan refers to it, he has the descriptor living / residential and visitor accommodation. What's your view on whether there should be any living activities other than visitor accommodation on the site, Mr. Bonas?
I think through the joint witnessing statement, we agreed that
That's
75 units.
Was it?
There wasn't anything fundamentally horrible in terms of living.
75
accommodation.
Visitor accommodation units or 75 units? Because they're very different.
75, well, it was actually rooms in a hotel. I think if I could phrase it correctly.
All
so
right.
the consent provided for 75 rooms in a combined integrated hotel.
Okay. So what do you say ought to be the status of living activities on the site, separate from, let's say there's an explicit provision for visitor accommodation as a permitted activity up to 75 rooms. What do you say should be the status of living activities generally?
I've recommended that those be permitted, and there were associated noise standards that I've recommended as cross-reference in terms of acoustic standards to bring that into line with what's applied within the town centre, the city centre.
But the consent doesn't make provision for living activities other than visitor accommodation. So why are you saying that? I mean, this is sort of slightly inconsistent in terms of the council position that this should allow what the resource consent enables, but no more. Where has this notion that, oh, we'll make an exception and people can go and live on the site come from?
It was a matter that was discussed in the joint witness statement. I'm comfortable with living accommodation within commercial areas, subject to associated sewer standards around nuisance. For me, it wasn't something, especially at 75 units, that was going to have consequential effects in terms of any of the other wider strategic provisions. But I do take your point that it creates an inconsistency in terms of the overall recommendation around the zone. But that's largely predicated on the retail distribution effects and also the transport effects. And I wouldn't consider that living accommodation would provide or result in any of those conflicts.
Mm. Okay. Yeah, I see your recommendation here, permitted where the total number and and there's a note, sensitive activities must comply with the noise insulation requirements and noise S33. Yeah, okay. All right, no, that's helpful to clarify that. Thank you. And you'll be pleased to know, at least for now, I think that's all of the things I wanted to just have a brief chat to you about. Okay. So no, thank you, Mr. Chair. That'll do for now.
There's a little bit left.
Back to the witness. I hope I don't make too many bruises on you personally in the course of the day.
No, you are wonderful. It's Sue job.
Okay, thank you. I just wanted to start with the fact that we've really got three different versions of commercial plus in the regional zone. We've got your version of your evidence. We've got Jeremy's version of his zone, and then we've got Jeremy's markup of your commercial plus.
True.
And his evidence. So start at the pen with draft, and that's what we have in front of us in terms of the recommendations from yourself and from Jeremy. That's correct, isn't it?
It is. The only addition is planning evidence from Wakakatoa, Hapu, and as to status.
Yeah. So have you turned your mind to Jeremy's markup of your commercial zone, and is there anything particularly offensive in that markup? Presume it's kind of wet, but his concepts onto your zone.
Not in any great. There's nothing offensive in any great depth, but I'm saying that as well. I haven't gone through it probably to the degree that it deserves. So I wouldn't want to. Perhaps that's something that I can come back tomorrow in terms of a right reply in 10 days and provide a more appropriately considered, because I think I'd be doing Mr. Brophy a disservice if I try to answer that question now.
Yes, because what I'm observing is that certainly the pre-hearing process has been productive. We are grappling with this ugly position whichever way we go because of the complexity of the issue. I do want to encourage, I suppose, further, I think you put it in your summary statement, the further work we'll get to tomorrow.
No, I agree. It's highly certain. I think that the joint witness statement process was brilliantly done, and witnesses for Blue Haven, especially Mr. Brophy, took considerable endeavours to go through and provide examples and templates, which served us all extremely well. We've got to where we are in terms of the recommendations, and I think there's some critical elements or decisions that need to be made within that. But as I hopefully identified within the PowerPoint, there's a lot of commonality, and really it will come down, in my view, to where do we collectively, where does the panel collectively sit in some of those bigger decisions, and then when that lands, I think the polishing exercise is probably relatively straightforward, because there is a high degree, I would suggest, of goodwill between them.
We have a procedural issue that we are not issuing our decisions sequentially like we did in Christchurch City. So,
Understand. Yes, look, I think
sort of a, but I suppose from a practical point of view we will be assisted by some further work or some direction. So Kit and I will have to talk about that to see whatever we might decide on.
Well, and to assist, I identified Mr. Brophy's modifications to the recommended conversions list. I do need to sit down and provide a more considered response to it, which I will do over the next couple of days, and provide a more considered response in the 10-day right of reply.
That's fine. So I just wanted to cover a few things that it hasn't. But one, the term of phrase about you accepted the cost was sunk. What do you mean by that?
Essentially, and it's probably a poorly used economic term by a planner who should know better than to use it. My understanding of a sunk cost is it's gone. It's there. It has to be accepted. So if it's a sunk cost, if it's an accepted cost, what is the responsive planning process or mechanism to deal with that? If we accept, nothing's been built on the Blue Haven site, but there's 34,000 square metres of floor space that has been consented. If I accept that 34,000 square metres as a sunk cost, i.e. using the Hawthorne environment, it's there, even though it's not generating effects, we kind of have to pretend that it does. What is the planning response to that? And that's what I need to know. That's a bit more.
So it's not the sunk cost of the $8.5 million that Blue Haven's
No, not at all.
spent. That's not what you're talking
No,
about.
it's the sunk cost in environmental terms and environmental effects that consent as if it was realised and if it was occurring.
Yes, just in your paragraph 91, you talk about the Macro Valley case. This was the Harbour District 1 where they had a year strategic plan. So I think that decision was in the context of full consent. And making, were you involved in that?
No, but I was involved in a subsequent plan changes 28 to 33 with Mr. Hayes, which flowed from a similar exercise. My understanding it was around the Carpo 2030 now, so long ago. Yeah, that went through a consultative exercise.
Yes.
And effectively, my understanding is it identified growth nodes around the area, and my understanding of the Environment Court decision was we can give that weight because it's a management plan prepared under the OGR. We can give it substantial weight because it's now gone through a consultation process. So it's effectively how do we weigh these things up?
Yes.
And we can give these management plans far more weight if they've gone through a consultative exercise.
was involved in that geothermal parties.
Ah.
Yeah, release of land and capital as well. So the next question then sets us up with the non-loitering from the city centre strategy. Has that gone through an LGA consultative process?
My understanding is it's had consultation and feedback on it. But I'll confirm that tomorrow in the
In the LGA consultation?
not a special consultative procedure, if that's the question. No, it hasn't. My understanding.
Given that you're setting up.
It goes to weighting, and I think it does provide more weighting gone through a submission and consultative exercise, which the non-motion plan has. There has been feedback. That feedback, I understand, went back to council before they ratified that plan. So it's part of the package before the non-motion plan was released.
Any questions about scope? Really,
I'm not council. I'll do my best to stay away from them.
yes, although you do cover it in your evidence. Talking about a particular form of thinking, what is that? What does a particular form of belief mean?
Sorry, so what paragraph?
Paragraph 102B. So, two issues with living with whether the scope of the solution is broad enough to include a particular form of belief.
Essentially, the point it's making badly there is, does and this is in broad terms, not necessarily this particular instance, does the submission, is it firstly on the plan change?
Yes.
And secondly, how wide is it? And if you end up in the middle, then that's still within the scope of the submission.
I just had a question about the new law requirement. Pedestrian bridge that Megan talked about. Not familiar with that, or for you?
I'm not familiar in terms of where it's landed. I understand there's been discussion.
That would look like the area. Sorry.
If it's built and it's funded and everything else, then yes, it's relevant.
Not.
Yeah, however, they're going through the business case at the moment, which is looking at all different options for the positions along the river. So it's very early days.
No consent yet.
I can see there's some funding in the LTP for the work or the investigation.
I don't think so, but I'm not sure.
I'm just interested, I'm thinking again, you know, if that was in place and there was pedestrian walking access,
And then that does change
it changes the link between the CBD and the medium density MUS, I suppose, where residential is looking to be encouraged.
Yes, from my part, I've identified the immediate residential catchment. I think it's figure 1, figure 2 within my evidence.
Yes.
My understanding in the alternative, that is the residential catchment, factual and environmental.
Right. So I want to talk to you about your 168 to 170 now. And this is the same question I asked Mr. Heath. This is you saying that there hasn't been a sort of a centre's assessment impact analysis. No such assessment has been provided. What is your advice to us? Is it the same as Mr. Heath that we don't really need that? We've got enough information to make a good decision on this? Void of that assessment?
The appropriate economic view is the one provided for by Mr. It would be. I'm not appropriately qualified to stray into that. The only point that I've made with that paragraph, I think it still holds true, is that there isn't one in front of it. There's a reliance on a consent.
You are qualified to look at what assessment effects might be. You are a commissioner. Yes. Your opinion as an experienced commissioner.
The point I would raise is the one that I've included with, it isn't a JW, it simply identifies that without an assessment, we were in the place of not being able to understand or have some commonly held views as to what the effects of the BCL proposition would be in terms of the wider network. As a consequence of that, it is very difficult to set policies, objectives, policies and associated provisions. Where we ended up with is this disparity between Mr. Heath and Mr. Thompson. Mr. Thompson, I understand, at least initially, was relying on the, it's already been consented, those effects are there, no further analysis is needed. It provided a very targeted assessment. My evidence in reviewing through and comparing and contrasting Mr. Heath and Mr. Thompson, I very heavily fall on the side of Mr. Heath, but not just because he's the council witness. I've gone through very, very carefully, it's obvious, and compared the two. So my view very much was, according with Mr. Heath's analysis, that there would be significant and enduring effects from BCL. There isn't this broader assessment that would otherwise assist us as to how it would fit in and integrate with sort of wider growth. There isn't. So essentially where I end up with is I've got contrasting economic evidence on a very specific matter. I then have to pick a side, whereas if there was broader economic evidence, there might be more nuance that's available to us. I don't think that view's dissimilar from the one that Mr. Heath put together. Essentially very site specific, based almost like a resource consent application. It's probably enough, but we would benefit from something else to be more nuanced. Sorry, it's taken me a very long time to answer that question, but ultimately, from a planning perspective, that's where I fall. We've got contrasting views. We've had to land one way or the other. There's no room for nuance without that broader assessment.
And that's where you end up in the joint witness statement.
It is exactly, and I think it was the first one where there was a dispute between the planners and the economists, and I identified in my view these are the steps that I would need for me to actually form a view.
So the planner, you need those steps. How are we different in terms of our role?
Well, I think it's identified by Mr. Heath and by myself now. You're in the unfortunate position of having to pick an economist because they're so far apart. Apart from the sales figures, which is Mr. Heath identified, pretty similar, but it's very, very narrow. It's very narrowly focused to what does BCL do to everything else, rather than how does everything else grow and develop together and how do we shift and move these things. So the recommendation that I've given you is based on the evidence that I've got and the view of Mr. Heath, which is I've got enough based on a very narrow view to say codify, don't even contemplate going any further.
Okay, that is helpful. Thank you. I think probably enough for the moment.
Can I've got yeah. Can I? You've provoked a couple of questions from me, Stephen. If I could, if I could come in.
So for the moment would be now.
Yeah. There we go. All right. The first one up always takes the biggest hits, Mr. Bonas. Just reflecting on that conversation with Commissioner Daish, to some extent, that the extent to which we, I mean, the reliance on a resource consent to create an effects threshold is a pretty straightforward proposition. But I think the difficulty BCL faces is that they are arguing that they ought to be allowed to potentially take those effects further. And it's very difficult for us to understand what the effects of those extensions will be in the absence of knowing what the baseline is to some extent. So I think that that's where the argument becomes a bit fraught for them. But I think where they logically end up, and I think this is something that was discussed, is how you then manage those additions. And Mr. Brophy's proposition is that, and I think Mr. Thompson jumps on board with this in his evidence, is that, well, provided you keep it as a consentable proposition to go further, and you make sure everyone thinks about it really hard at the time, then that's the answer to it. But which I mean has a certain logic to it in a way. So the degree of, or the absence of information about that, though, really has to play home to us in terms of what status we give that additional activity, and what is the policy framework, what are the policy settings to make sure it is properly considered at the time. And I think this is where we've got three options on the table. We've got the restricted discretionary and some criteria that Mr. Brophy suggested. We've got your proposal for discretionary, and then at the other end of the spectrum, we've got Mr. Campbell and Ms. Mako and others saying it ought to be non-complying. So that's sort of how we're trying to manage this absence of information, isn't it?
But I agree, sir. And I think the thing not to lose sight of, regardless of where you land in terms of status, is the objectives and policies. Based on the evidence of Mr. Heath, in my view, and the recommendation that I strongly make to the panel, is that the city centre is vulnerable. Any increase moves us further away from what the strategic directions are saying the role and function of the city centre should be. Almost duplicating roles between Blue Haven and the city centre, and I would suggest you might end up with one winner, but that's probably a question for Mr. Heath. The policy settings, in my view, need to be very, very prescriptive and very, very tight.
Well, that's to some extent that's where I wanted to go next, because if we look at the proposed policy prescription here, we've got the standard sort of refrain that's been used in a lot of the site-specific chapters, where you allow a range of activities considered to be compatible, then you manage activities that might be potentially compatible, and then you avoid activities which are incompatible. Now, if we look at your proposed policies, the allow a range of activities that are compatible with the character of the zone in a way and at a rate that does not undermine the viability and vibrancy of the city centre. And that's where you've effectively set out those things which have been approved for the site by the resource consent and will generally be permitted to the levels within the resource consent. So that's sort of the sunk proposition. Your second policy, sorry?
Sorry, so it sounds like you were going to get to the same place I was. It wasn't in isolation. There's
well, then there's
CZ.
Yeah, well, P2 is managed potentially compatible, and then you also get another reference to the activity, and having regard to whether the activity will result in cumulative effects on the city centre zone, and then you've got some potentially compatible activities there. Then when it gets to the avoid policy, it really doesn't say avoid additional retail that might have an adverse effect on the city centre zone, which I thought, given that's the one thing that the evidence from Mr. Heath at least is saying we ought to be very cautious about allowing, why does the avoid policy not make it very clear that only in the very stringent circumstances will any additional retail be allowed on site? I mean, let's put it this way. Discretionary activity comes in for another 10,000 square metres of retail. You're the processing officer. Which policy are you going to point to one way or another to say whether it should be appropriate or not?
It would be CZP1 and CZP2, but an initial drafting of CZP3 did include the stanza that's now in CZP1 as to the avoidance. Again, it was the point that I've made, it's difficult to get a consent, put in the national plan standards, and then put it in the district plan framework. In my view, I take your point, and I think that statement about restricted range and scale in a way and at a rate is more appropriately put within P3 as an avoidance policy. It's not a natural fit with the rest of the framework of the plan, but it would be more directive and appropriate.
Well, just thinking about, I mean, most of my, my initial career was getting consents for things and finding ways through all of the policy framework. So I guess in a way, like many who now work for applicants, it's about making sure that the policy, as you've rightly acknowledged, making sure the policy settings are strong enough, and they need to send the signals to guide a decision maker in the context of in your proposition, a discretionary activity. And I think that's the point I'm getting to, is that I see enough wriggle room there for additional retail to be put on the table and be given a serious consenting proposition, because there's nothing there that says it might have effects beyond the pale that the policy settings are trying to avoid. Anyway, that's probably something just for you to have a reflect on when you go through Mr. Brophy's suggestions in terms of your provisions. Anyway, those were the other matters. Thank you, Mr. Chair.
Thank you. So I think we are finished with the council's position at 2:20. So, that's the opening position. Mr. Campbell, would you like to forward? How's the audio? People on the end of the line?
Very good.
Okay. So speak up, head up, right?
Yeah, no, Mr. Brown's suggestion of we oldies turning up our hearing aids worked quite well, so we did.
Oh, thank you.
Good afternoon, Commissioner. I will make my summary brief. A short statement of evidence. Largely, my evidence is in support of the Section 42A report. Today. So, yeah. Recommendations. The only point of difference, as has been touched on, is on the far end of the spectrum, as Ron suggested, in terms of a suggestion that in respect of the infringements to the NFA, net floor area controls, I'm suggesting that it would be appropriate to make those infringements. I did interested in the line of discussions that Mr. Littlejohn had. That being strengthened if that was considered appropriate. Happy to answer any questions.
We've got the benefit of Mr. Campbell in person, because I think he's been out and about looking at the city, the planners around the medium density residential zone. That's right, isn't it?
Yeah, we had a good sort of 3 or 4 hours driving around. We've really been.
Okay.
Yep.
Any clarification needed? I think that short summary does encapsulate where Michael's sitting at.
Yeah, no, absolutely. I guess the only, and I appreciate you being there in person, Mr. Campbell. Your evidence. I didn't have any particular questions on the evidence, but I did want to circle back and talk to you a little bit about the strategic objectives and some of the discussion I've had with with Mr. Bonis this morning, and I guess the first one is your view on, because it wasn't a matter that I alighted upon initially when I read Mr. Bonis's 42A report, this notion that it would not be appropriate to call or refer to this site as a centre, because then that leads to follow-on obligations on the council under Objective 3 of the NPSUD. Do you have a particular view on that?
Well, I certainly share Mr. Bonis's concerns with respect to the overall there's been discussions around the hierarchy of centres and I've under previous topics been questioned in relation to the city centre and the role. And so I still remain of the view that the significant historic resources and investment into the city centre means that, from my perspective, it's imperative that the objectives and policies recognise that, and it provides, to my mind, the best opportunity to encourage a well-functioning environment, particularly around intensification, accommodating residential growth, not just in the city centre, but because of the, I guess, the physical attributes of New Plymouth, which kind of radiates out from the city with its network of sort of public transport routes, much like a bicycle spoke radiating out from the centre, that sort of encourages medium density housing within the local centres and the town centres, but also supporting the city centre. So when I look at it, I look at that sort of overall sort of framework of centres, but also the residential zones working currently to kind of support the city centre. And I guess from that perspective, I've tended to look at the subject site more as a spot zoning, which I share Mr. Bonis's view that really it is to a degree a reflection of its existing resource consent. That's where I share my concerns around potential for that to expand beyond that scale.
So just reflecting back on UFD 16, 17 and 18 in particular, which talk about the hierarchy of centres and the like, do you share the same view as Mr. Bonis that the commercial plus precinct approach that he is recommending and that you support with a few minor variations can live in the plan as an area specific proposition without any incongruity with those strategic directives in their current form?
It can, but I think that's imperative around how you structure to the extent, to the scale that has been recognised.
Yeah. Okay.
Look, I acknowledge it's not a perfect fit here, and to a degree there's a degree of pragmatism in that.
I mean, there's a very old adage that no plan of battle survives the enemy's first salvo, and that's very much what's being played out here. And to some extent, we've got to be adaptable to what has happened historically. So, but I take your point about making sure that how that is acknowledged doesn't, I guess, infect and undermine the entire approach that the council wants to see. It's about constraining it to some extent. Yeah. What do you have a particular view on living activities at the site other than visitor accommodation?
Yeah, I guess from my perspective, I would, once again, I guess, and Mr. Bonis touched on this, plans evolve and they do grow. I guess at this point in time, I'm a bit wary of encouraging too much residential in this area in particular, but I wouldn't rule it out in the future. I think it's a case of probably, watching these areas evolve. But I think from my perspective, there are other areas which should be more encouraged in terms of residential, that have that broad spectrum of not only sort of commercial activities, but social and community activities that can provide a wide spectrum of benefits to the community. I'm not necessarily convinced that this site yet has has good access to those amenities.
Okay. All right. Thank you, Mr. Campbell. Nothing further? Yeah.
Thanks, Michael. I just have a couple of things. Have you read the Blue Haven evidence, Mr. Batchelor, Mr. Thompson?
I have, I have to confess very
Here's-
quickly, but I have.
I suppose, Mr. Thompson gives us strong evidence, I think, that his experience in other centres and other cities, that the Blue Haven proposal as a sub-region centre will have less than minor effects in these Plymouth District Council. That's a paraphrase, I think. He uses that term, minor. And Mr. Batchelor, Mr. Batchelor talked about his Hamilton Tauranga experience, where the CBDs have had yet to cope with that, two significant commercial establishments coming in on the edge of the city. Yeah. And I think when Mr. Thompson did some supplementary evidence, we asked some questions on this topic. His evidence to us, or what I took out of it, was that when the CBDs are faced with competition, they have to get up and do better. CBDs do bounce back and reform themselves and do become quite vibrant in the experience, particularly Hamilton and Tauranga. So that's what I've taken from that evidence. Do you have any reflections on that?
Yeah.
Is that your experience as well?
Well, certainly, I think my experience is that out of centre, our centres will significantly have the potential to significantly impact on existing centres. Quite often, historically, they've been in an isolated event. I think one of the points of difference here is that we're looking at an overarching change to the planning framework, not just in New Plymouth, but a lot of centres and a lot of plans are going through plan reviews, not just sort of looking at retail strategies or town centre strategies. They're looking at their overall growth strategy for what constitutes a well-functioning urban environment. So to my mind, it's not necessarily just about looking at the retail aspects, it's also looking at all of the other zoning patterns. Proposal for additional mixed use with the residential precinct, city centre, the proposals for additional residential intensification. I think all those things are intended to materially seek to support the city centre, and I guess my concern and having reviewed the evidence of the economists is that I think there are going to be some significant economic effects, and they do have the potential to impact on objectives, not just within the city centre, but in that sort of wider area.
Thank you. I'm looking at your 5.4, Michael. And this goes to weight that we might give to the reverse consent. Consider that too much weight is given, you're saying you should really go back to the industrial zone. We've heard from the industrial zone hearings on, I don't think it was on it, that there is quite an oversupply already of industrial land in respective of this area. So given the fact that we've got this site where it is, not any capacity issues around that. How would you, in your experience, I put us on the spot, how would you go as to weight?
Well, I agree. I mean, in terms of the existing resource consent, I think it should be. I'm not saying the residential industrial land supply, but it is an attractive site. I can understand why it has that degree of attraction, particularly that size. I think it would still be an attractive site for industrial activities because of its size and topography. So it's still attractive for those types of activities. But from my perspective, I think it is reasonable to recognise that resource.
What about recognising the fact that we've moved the contaminated site on the edge of the city beside some important streams and waterways to a safer site? Does that weigh at all in your mind? Yes, so the Ravensdown site is heavily contaminated.
Sure.
Through the activities of Blue Haven, stage one.
Yeah.
You know, in a way, it's like would you see it as an asset that has been done, and the city now has this flat, vacant, contaminated, free?
Sure. And you know, remove the existing building was somewhat of an eyesore as well, and so that's positive for the urban environment as well. So I think there are material factors for why I don't think it's unreasonable to recognise the existing.
Thank you. Anything else, Kit?
No, it's good.
No. Thank you, Michael. Okay, we'll back to Auckland. I think we are moving now to Waka Kotahi. Evidence from Capital Place Hearing Church, all online as well. So welcome back, Waka Kotahi team.
Kia ora koutou, sir.
Thank you. So, Kat, you and Terry have provided a bit of a summary. You just want to flick through that quickly for us?
Yes, sir. I will probably go first, but I'll just let you know Mr. Catchpole is here for questions as well. He's just settling in the background.
Yes.
And also at this, before I launch into my summary statement, I would just say that in addition to the papers you have before you, I've this morning had the opportunity to review the legal submissions from Ms. Barry Pacino, and I will make some brief comments on just a couple of matters in that which piqued my interest as I read this morning. So if I could perhaps start at 1.1 and 1.2, where I summarise my name and qualifications and confirm that I have read the evidence of Mr. Campbell, Mr. Walker, Mr. Brophy and Mr. Batchelor. I'll deal first with the Hamblin submission. Mr. Walker confirmed that the relief his client sought was to move to a mixed-use zone. There has been nothing, sir, that I've seen so far which would change my position as expressed in my primary evidence. Sorry, sir, I should have checked. You have pre-read our summary statements or not yet?
Not they've arrived on my desk through the course of the hearing. So
is it helpful then if I actually just read through them?
They're not very long, are they?
No, sir, not terribly long. Just a few pages.
Okay, I think just go through them.
Excellent. I'll start at 1.3 then on the Hamblin submission. Mr. Walker confirms that the relief sought to change the zone from general industrial to mixed use, and it is not to adopt, excuse me, adopt the Blue Haven position or to alter other plan provisions. Mr. Walker's relied on the Section 42A report for the rezoning of, what I'll just refer to as the Devon Road sites, which are the sites to the north, which we will hear from tomorrow from Mr. Bryant. And that Mr. Walker has also confirmed that he considers rezoning the Hamblin site for mixed use would complete the mixed use zone linear strip along the length of Devon Road before transitioning to a more retail centric Blue Haven commercial zone. In my view, Mr. Walker's description highlights my concerns regarding the cumulative effects of the proposed rezoning, both for the Hamlin site and also for the Devon Road sites. As for the Devon Road sites, there is no transport assessment of effects of the proposed Hamlin rezoning. Mr. Church has identified both in both his evidence briefs that the increase in development associated with the mixed-use zone will result in transport effects which have not been assessed and would likely require mitigation. No mitigation has been proposed. Based on Mr. Church's evidence and my own assessment, I agree with the 42A recommendation to retain a general industrial zone. In particular, there's been insufficient or no transport assessment. The submitter's requested zoning will provide for higher trip generating activities, which will impact on the already constrained transport network. The proposed rezoning should be more widely assessed in terms of its ability to achieve the plan objectives of decreased reliance on vehicle trips, and the proposed plan transport chapter provisions are not well placed to manage the potential effects of the rezoning. The time of the rezoning is therefore, in my opinion, the timing of rezoning is the best opportunity to assess and manage transportation impacts. For the Blue Haven site, based on Mr. Church's evidence and my own assessment, if the panel determines an alternative zone is appropriate with some modifications, I would support a precinct approach, but consider the choice of the underlying zone as a broader strategic matter which can be determined independent of the transport provisions, which themselves could function within the precinct structure regardless of the underlying zone. The provisions of Mr. Bonis, subject to amendments as described below and in my attachment 1 of my summary, sorry, that's another matter I support, in regards to a preference between Mr. Bonis's provisions and Mr. Brophy's provisions. Should the panel prefer the sub-regional centre zone as proposed by Mr. Brophy, I do not oppose that zoning, provided that there are substantive amendments to the provisions to ensure appropriate transport outcomes. I remain of the opinion, however, that the sub-regional centre zone is more weighted towards provisions which support a centre, i.e. more permissive provisions for a wider range of activities. There are a number of matters raised within Mr. Brophy's evidence, which I will briefly comment on, in addition to providing detailed feedback on Mr. Brophy's sub-regional centre zone provisions and his proposed changes to the Section 42A commercial zone provisions. At paragraph 114, Mr. Brophy records, I may have perhaps taken that as read. A moment there. I agree with Mr. Brophy that the general structure and purpose of the transport rules is agreed, but as recorded in my primary statement, I do not agree that the detail of the the sub-regional centre zone provisions have actually been agreed. I think that's evident from the amount of comment I've made on the details of those particular provisions in the attachment to the summary. Mr. Brophy also proposes that Transport Rule 10, which is the high trip generator rules, do not apply to the site and has identified an alternative. For the reasons outlined in my paragraph 115G and F below, I do not support this approach unless additional matters of assessment and notes duplicating Rule 10 in the transport chapter are included within Rules 23 to 43. In paragraphs 1.2 to 1.3, I've just summarised that signage appears to be being dealt with in a later hearing, and that if necessary, I'll provide some further commentary there. Now, so I'm not sure how helpful my next provisions will be to actually go through and read out, but paragraph 114 and 115, which covers the majority of the rest of my statement, which you've already seen, just sets out the details of areas where I don't agree with Mr. Brophy's amendments to Mr. Bonis's commercial zone. And 115 does the same, where I have differences in opinions on Mr. Brophy's sub-regional centre zone. I think I can go through those, but I'm conscious that they are quite detailed and would probably require cross-reference to the attachments 1 and 2 to be helpful. Yeah. I'm happy to do that if that's of assistance, but.
For me, Kath, appreciate you've written those out, but maybe if you just go to your attachment 1 and attachment 2 and just give us a summary of the key changes as you see them, like we can see them in front of us.
Yes, excellent.
But maybe just take us a little bit of a roadmap through the provisions.
Right, so I'll start with attachment 1, which are Mr. Brophy's amendments to the 42 report. For policy 6, which is noted there, that reflects my preferred changes, I prefer policy 6 to Mr. Brophy's policy 7, and the changes you see there are my proposed amendments to this 42 report, which I think I understood Mr. Bonus correctly this morning, saying he was comfortable with, but maybe perhaps confer with him there. If we move, the next amendment down is a very minor wording error, change on transportation. If we move down to area B on Rule 21, which is the transport provision, which controls or requires works to be undertaken before there's development in area B, and the same change applies to areas C, D, and E, which is the provision immediately below. You'll see red text there, which refers to quality bus facilities being provided in point 3 in the first one and point 5 in the second one. And you'll also see there that there is suitable functional bus access proposed in point 4 for area B and point 6 for area C, D, and E. So these are matters of discretion which would be triggered at the time the physical works consent is required for development in areas B, C, D, and E. And these reflect Mr. Church's concern that whilst there is a line on the plan with public bus connection written on it, there are no other provisions in the either the Mr. Brophy's provisions or Mr. Bonus's provisions, which actually provide any assessment beyond there's a blue line on a plan. So we have sought to provide a little more guidance for what would be expected in terms of both facilities for passengers on the site and also making sure that the bus can actually physically access the site and manoeuvre through the site. Excuse me.
Thank you, Kat. Carry on.
Yep. So this is probably one of the most critical things which I'm concerned about within the both Mr. Brophy's additions to the commercial zone and Mr. Brophy's sub-regional provisions is the notes there you'll see struck out in red. These follow Rule 1. So Rule 1 is the rule that says in Area A, restricted discretionary activity, assuming you have built XYZ road infrastructure. As Mr. Brophy alluded to before in response to a question, he has proposed notes which basically say Rule 1 will fall away once the infrastructure is built, and that Rule 10, which is a high trip generator from the transport chapter, also does not apply. So effectively what that would mean under both the commercial zone preferred by Mr. Brophy and Mr. Brophy's sub-regional centre zones is that once the roading infrastructure is in place, Rule 1 would cease to have any effect, which on the face of it seems quite sensible, except in addition to requiring the transport upgrades, Rule 1 also has a cap of around 13,000 and something square metres of an activity which we're still debating whether it's large format retail or trade centres, etc. So if you dispose of Rule 1 by the note proposed, which I've struck out there in red, you also dispose of the 13,000 square metre maximum floor area, which is provided for by that plan. And you also concurrently exempt any further development in that area from having to comply with Tran 10.
Thank you.
All right.
Clear to me.
Okay. Moving to the following matters for rules 2 to 11. Now, I've proposed these changes in the event that Mr. Brophy's notes were accepted within the commercial zone provisions, and effectively these provisions are proposed to include transport assessment where the floor area caps are breached, and I have utilised the work already put in by the drafters of Rule 10. I think they very adequately cover both matters of discretion, but also more importantly, the notes at the bottom require number 1, which is an integrated transport assessment. That's on the top of my page 9 there. And to try and tie that back into ensuring that there is an appropriate transport assessment in the event the notes in the preceding point are included in the provisions. If they're not included, then the existing Rule 1 would capture the matters which I've outlined in the matters of discretion that I proposed for Rule 2 to 11.
Okay, thank you.
Right, so I'll turn now to the sub-regional centre zone, which is on page 10. So just a couple of minor suggestions on objective 4 and 5 to refer to the transport network. You'll see there I have proposed to strike out policy 7. So as referred to in my commentary on the commercial zone policy 6, I prefer the wording that I put forward in my evidence, and I think Mr. Bonis has agreed with. So that would be the replacement text for policy 7. In precinct area A, there were 2 items that I have proposed for additional assessment criteria, which I think I've understood from Mr. Brophy's table today he's accepted, but I will need to confirm that because I've been trying to read that this morning whilst I was also trying to listen. So perhaps I could check that and come back later. But both of those things are important. One of them, sorry, F and G reflect the updated precinct plans and also conditions of consent. Item H, which is at the bottom of page 10, Mr. Brophy very kindly considered a notification statement should be included in his provisions, which required notification, identified Waka Kotahi as an affected party for any applications sitting within Rule 1 and Rule 22. They are both the provisions which allow development, consider development as a discretionary activity where infrastructure is not in place or not completed in accordance with the conditions. I had some question in my mind, at least, whether or not require or predetermining that a party was affected in it by a notification statement in a plan was appropriate. And whilst I'm sure Waka Kotahi appreciates the thought, I thought that notification or consideration of that might better fit in the restricted discretionary category, and that it may be moved to consultation and the outcomes of any consultation being reported as part of the restricted discretionary activity, rather than a mandatory notification requirement sitting in a discretionary activity notification statement. So you will see that that is reflected in a number of the changes I have suggested in Mr. Brophy's provisions, simply because it occurs in more than one location. Right, moving to page.
There's a wee typo in H, I think, Kath, the consultation in any around the wrong way, is that right?
Yes, that would be correct, sir. I will. Good spotting. Thank you. That error may repeat itself further down, I suspect. Indeed. So top of page 11, you'll just see my preference to delete the notification statement. Immediately below that, you'll note that I have recommended deleting Mr. Brophy's area B controls. Those require restricted discretionary activities for development within Area B. Now, Area B is the parking area, if you like. As with my comments on Mr. Bonis's primary, his 42A reports, I have suggested that those items could be permitted and should be provided for. There's no specific need to control those, I didn't think. The only time they would need control in Area B is if something other than parking, active mode and public transport and landscaping and ancillary structures were proposed. So I've suggested an inclusion there. Next item down, if I refer back to my comments earlier on the notes which Mr. Brophy had proposed to install in the commercial zone, which resulted in the effective deletion or no need to comply with the rules in R1 and R22, and also the removal of the need to comply with rule R10. So that's the same point as for the commercial zone. I don't support those. The next item down, on Rule 22.3, I had some changes proposed to the floor area for the activities. And I understand from Mr. Brophy's table this morning that he agrees with the changes. It seems there may have been a calculation area, but again, I will need to check that in closer details. Certainly the figure for one of these items came down to around 16,000 to ensure that the totals added up. The main takeaway of this, if I may, sir, rather than worry about how many square meters everything is that the basis of the square meters which I'm proposing are reliant on the team traffic report, which accompanied the land use consent. That report's really critical because it forms the basis of the transport mitigation. And I think that is a really valuable piece of work in terms of identifying what's proposed to be built and what the effects are likely to be. And there's been a lot of discussion earlier about relying on the land use consent or not. In my opinion, the critical thing here is relying on the technical reports which have been provided, and some of those do form part of the land use consent. And in that regard, the team traffic report has got a range of very helpful figures, and it's my opinion that those figures and activities as close as possible to match the plan as reflected in the team traffic report should form the basis of transport provisions for the overall site should it be adopted by the panel moving forward. Turning to Rule 22, these are a couple of additional assessment criteria recommended to reflect the outcomes of the transport caucusing, which are covered off there. I've also just noted, I think there's a duplication with my struck out item 2 that's included earlier above. Turning now to page 12, and the similar changes are proposed to, excuse me, reflect buses and public transport facilities. And similarly, sir, you'll see there number 7, the same cut and paste error. And again, if I'm looking at R22 area B, partway down page 12, we have the same bus and consultation recommendations for inclusion in restricted discretionary activities. And lastly, or not quite lastly, actually, the last item on page 12, if the notes proposed are Mr. Brophy's provisions, which I'll say it again, delete transport 10 and delete the application of rule 1, remain included, then again I have recommended matters of discretion to deal with transport effects where floor level areas are exceeded, and again they are a direct copy and paste from Tran 10. I'm quite comfortable with those in terms of gathering effects. And last but not least, on page 13 you'll see a small extract from the map which is attached to a precinct plan which is attached to Mr. Brophy's evidence. As Mr. Church will address shortly, he has recommended that the word public be removed from the key and that just be a bus connection. He'll address that in more detail, but the general proviso is, or the general understanding of that is that the bus could be run by perhaps a private entity, and that this removing public doesn't place any onus on the public bus operator to actually form or use it in the future. So, sir, happy to take questions now or after Mr. Church has spoken, whatever is most convenient for you.
I think, Kerry, if you could just go through yours and we'll ask questions together if the evidence is connected.
No, I'm fine to do that, sir. So if you've got my statement, I think I'll just do the same as what Kath's done and just take you through the summary statement as issued this morning. 1.1 and 1.2, I just set up my name and my experience. 1.3, I've also read the evidence in chief provided by Mr. Walker for the Hamlins, Mr. Brown for Blue Haven, and also Mr. Brophy. So just addressing the Hamlin submitted first in relation to Mr. Walker's evidence. Mr. Walker discusses transport matters at paragraph 37 through to paragraph 40. I remain of the view set out in my evidence in chief, which is to retain the general industry zone. as no transport assessment or transport evidence has been provided to support the proposed rezoning. My comments on Mr. Walker's evidence are as follows. Mr. Walker suggests that suitable control on traffic-related effects is embedded in the proposed district plan, noting that transport assessment prepared by a suitably qualified person as per Tran P6 is required with high traffic generating activity set out in Tran R10. And that is a threshold, I guess, in terms of daily trips of up to 200 additional trips or generated trips per day. While a transport assessment has not been undertaken for the Hamlin site, we do have the benefit of understanding the predicted performance of the transport network fronting the site once incorporating the Blue Haven development as assessed through the Blue Haven proposal. And that's coming back just to what Ms. Hepplethwaite just referred to was the team traffic report. So that sets out, I guess, an understanding of what the predicted network performance will be subject to the proposed Blue Haven activities being placed on site along with their mitigation. So I refer back to my evidence in chief, which summarizes the predicted performance of the mitigation proposed to support the Blue Haven site, which includes signalizing the Devon Road and Karteri Road intersection. It's important to note here that the intersection is predicted to operate with level service E and level service F, with the degree of saturation above the practicable capacity of 0.85. So essentially what that's telling us is that there's little capacity that exists about the immediate network to allow for further intensification of the immediate area without further assessment. The mitigations obviously provided sufficient capacity and improved safety to accommodate the trips anticipated by the Blue Haven site, but nothing's been looked at thereafter. So while an ITA would be required for a high traffic generating activity, I'm of the view that it would be very difficult to decline the application or persuade the developer to significantly alter their proposal to reduce the number of trips generated to a level that can be accommodated safely and efficiently onto the surrounding network, should the activity being applied for be consistent with what the zoning allows for. So until such time as a development proposal for the site has been considered, with a transport assessment outlining the predicted effects of the land use, I retain my position that the Hamlin site remain general industry zone. So that's in relation to Hamlin. Just turning now to the Blue Haven submission. I guess my overall view is that I support the rezoning for the Blue Haven site, provided the changes to the provisions contained in Ms. Hepplethwaite's summary statement are adopted, and she's just taking you through those. The changes to the provisions are required to ensure that transport effects are addressed. In relation to Mr. Brown's evidence regarding public transport, during expert conferencing, and as discussed on page 7 of the joint witness statement, Mr. Brown noted that there is a consented transport centre within the Blue Haven development, which should be added to the precinct plan. At paragraph 17.4.1 and 17.4.2 of Mr. Brown's evidence, he reiterates that passenger transport connections were recognised in the consented project, and that he would expect an alternative development proposal will incorporate facilities to help support multimodal travel as an alternative to the use of the private car. In my view, there is no requirement in the precinct provisions to require some form of public transport facility, and no detail that ensures using buses is an attractive alternative to private vehicles. I note that a public bus connection is shown in Precinct Plan 11A, but Precinct Plan 11A is not connected to a standard. I appreciate that the bus providers will determine whether buses enter the site or not, and as such, the inclusion of any standard requiring an attractive passenger transport hub or facility that connects with open space and pedestrian connections internal to the development needs to be flexible to be either on-site or alongside a public road where the bus services currently operate or may operate in the future. Turning to Mr. Brophy's evidence, and continuing the discussion on public transport, Mr. Brophy at paragraph 70 of his evidence discusses how the Blue Haven development is designed to enable a public transport node. So again, while Precinct 11A has been updated to include a public bus connection through the site, the provision remains silent on requiring a public transport hub or node and connection. The planning and operation of public transport services requires routes which are reliable and are designed to allow for public for bus service to operate efficiently and safely. There's also the role of the service provider to determine what the most appropriate routes are and provide the necessary coverage. So connectivity and reliability to benefit the community. So while I support the concept and opportunity for public buses to enter the site, I have some reservations on defining a public bus connection as shown on Precinct Plan 11A, as this may place the onus on the public bus provider to pass public buses through the development. This may not be the preferred route of the bus operators, with no consultation or evidence presented from the bus provider agreeing to the route shown. I therefore recommend that public is removed from the legend in Precinct 11A on the precinct plan. Further, no supporting design guidance on the bus connection is included in the provisions. This would include both design to ensure a bus could maneuver through the route proposed, if this is preferred, comfort on waiting passengers, and whether the location of the bus stop would be in a convenient location to encourage use. While I support the concept, my recommendation is for the provisions to include a matter of discretion in Mr. Brophy's commercial zone provision, Precinct 11R21. And I've just got the reference there for when that goes through to the alternative rules, being areas C, D, and E, including a matter of discretion reflecting A, the extent to which a quality bus facility node is provided, for which is sheltered and is integrated with open space and pedestrian connections, and B, ensuring that if bus access is proposed within the site, it is functional, safe, and efficient. Ms. Hepworth-Waite has reflected these changes in her summary statement that she's just talked you through. There are several other matters raised in Mr. Brophy's evidence in chief, which I'd like to clarify. Mr. Brophy accurately reflects the agreement of the rule framework set out in the Transport Joint Witness Statement at paragraph 62 of his evidence. I do not agree with paragraph 114 of Mr. Brophy's evidence in chief, which suggests that Waka Kotahi are comfortable with the road upgrade rules as currently reflected in both the zone and the sub-regional centre zone and the commercial zone rules. I've set out in the joint witness statement where I am not comfortable with the rules and refer to Ms. Hepworth-Waite's summary statement dated the 27th of June. Where edits to the rules included in the appendix to Mr. Brophy's evidence in chief have been suggested. I agree with Ms. Hepworth-Waite's suggested changes. At paragraph 67, Mr. Brophy states that there are no concerns with any inappropriate design or construction methods that he is aware of. I note that I'm unaware of any evaluation of construction methods being completed to date, as these are subject to the detailed design first being completed. Traffic effects related to construction methods will be evaluated through the ARDIS matters of discretion set out in Mr. Brophy's commercial zone provisions. I remain of the view that the thresholds presented in Precinct 11 relate to gross floor area and not net floor area as included in Mr. Brophy's suggested provisions. And I guess just to add to that note there's some discussion this morning as well again related to net floor area and gross floor area. The one concern I've got, I guess, is in terms of transport guidelines and traffic engineering documents that provide for trip generation rates, none of them relate to net floor area. They all relate to gross floor area or gross leasable floor area. So in terms of the, I guess the added complication, while I can reflect the fact that there may be able to have a definition to net floor area, when it comes to the actual traffic effect and measuring the effect, I think there's going to be a wee bit of a problem in the future when there is no such guidance in terms of what the trip generation rate or the trip generation rate of a net leasable area is. So it's just a little bit of an added complication there for you to consider, unfortunately, in relation to how effects of the transport network are considered when making that determination. I'm happy to take questions. I've got my conclusions there, but I've already set those out.
Sir, if I could, I've just realised I failed to read my additional statement as promised on the legal submissions. Would I be able to have a moment to do that now? It's just, it's only 4 paragraphs, so it won't be terribly long, and I can supply those to you in a written version afterwards. This morning I have reviewed Ms. Barry Pacino's legal submissions, and there were 2 comments in there that I wished to respond to. The first one, and they relate to paragraphs 7.2 to 7.7 of her submissions. The first one is a comment about raising new issues not covered in conferencing. I'd just like to reconfirm that I've complied with the Code of Conduct for expert witnesses during the expert conferencing in the preparation of my evidence and in providing my oral evidence today. I've been appearing as an expert witness before Council and Environment Court hearings for more than 20 years, and I take my duties as an expert extremely seriously. There were two specific items that I was concerned about. That was the assertion that my evidence covered my and others' evidence, wasn't just myself alone. What if or but for scenarios. Just like to say that my evidence focuses on transport issues, and they address the transport provisions both in the commercial zone, which is my preferred outcome, and those which would need to be included if the sub-regional zone is included. I suspect that comment may be aimed at my paragraph 8.4 in my primary evidence, which discusses a what if the consent isn't given effect to in its full entirety, which is of course at the discretion of the consent holder, rather than whether or not the consent is part of the existing environment. The second matter which I've noted Ms. Barry Pacino indicates is that people or planning witnesses have introduced new issues, and in particular greenhouse gas emissions. I agree that greenhouse gas emissions are not specifically referenced in the planning joint witness statement. However, greenhouse gases form part of my assessment of consistency with the NPSUD and other plan objectives and policies. This is not a new matter. Greenhouse gases are an integral part of promoting alternative transport modes, and this was a point of discussion during non-JWS meetings between parties and has resulted in a number of changes, some agreed by Mr. Brophy, to provisions strengthening cyclist and pedestrian outcomes. The second matter which I would just like to address briefly is the assertion that I relied on Mr. Heath's economic evidence. I've not directly relied on Mr. Heath's evidence. Mr. Bonis has referred to and relied on Mr. Heath, and I support Mr. Bonis's overall position on the commercial zone. But my support for the commercial zone is for the range of activities and zone structure which ties more closely with the team traffic report, which, as I've noted earlier, is the key document on which traffic effects are assessed and mitigated. My evidence is focused on the transportation provisions of the proposed zoning, a matter which is not addressed within the legal submissions. So that was really all I wish to add, and as I said, I'll provide a brief written note if it is of assistance, which covers that off.
Yes, if you could please, Kath, send that to Christine and Julie.
Yes, certainly, sir.
I have just a question about that particular issue to kick off. If we need to rely going forward on the team traffic report, how is that tied into a zone provision? I know the case law around background reports really being closely getting the team to reduce consent, and they can be looked at. But with a new zone provision, how would that team traffic report actually be tied in?
Sir, I don't expect it to be written in the provisions, and indeed that's not proposed. The team traffic report forms a technical background report, in my opinion, which rules can then be formulated to reflect, and I think that's certainly been the case for the land use consent. And then obviously, as that has been pointed out, should a new zone be adopted, it would be the consent holders' prerogative whether they chose to rely on that consent or whether they chose to adopt the provisions of the new zone. So I have no expectation that the team traffic report would be anything but a background technical report.
Thank you. Look, I think we should probably just work our way through any questions now and then take a break after that. So do you have any questions for the team here?
Not on the, I'm off mute, yep, not on the technical stuff in your evidence. It is very detailed, and I'm not going to try and work my way through it completely now, but it's very helpful that you've set it out like that. There was just one issue, and I was just trying to find the source of it. There's a condition, I understand it, in the Blue Haven consent that sort of implies some sort of adaptive regime based on monitoring of performance of the intersection, and I was just trying to track down the resource consent to see where it was. Do you know what I'm talking about, Ms. Hepplethwaite? Are you familiar with?
Yeah, I have the consent open in front of me, sir. I will just have a quick roll through, but I am familiar with that condition. We've taken, Mr. Church and I have taken a pragmatic approach when transferring, if you like, the consent conditions into rules. And we have been more focused on ensuring that the effects which emanate based on that team report match the mitigation proposed rather than replicating word for word the review, because there is a review condition in there. Not sure how critical it is. I find at this moment. There we go, sir. It is condition 46. I could share screen if that helped.
Oh no,
Or
no, let me just find it. Let me just find it. It was in was material given at the hearing. Blue Haven resource consent final decision. Let me just pull that up. I might just have Mr. Sinclair's decision. I know. Oh no, here we go. Condition 46. So yeah, where are you, Ms. Hepplethwaite?
So I'm starting on page 31 and condition 46, and condition 47 require some pre-start monitoring and some monitoring after the date of completion of the stage 3 works. Condition 48 requires some information to go to council, and then conditions following from that indicate if there is an issue that the consent holder shall offer design solutions that council will consider and then install, and then there's a 128 condition as number 52.
Okay, all right. So it is a bit of a complete package. If within the consent there is I guess a response to monitoring that might result in some further form of amendments to the roading layout and various things like that, but that's the extent of it. The council would have to go on a review process if they wanted, if for example none of that worked and there was still significant congestion being caused by the site, they'd have to go on a review process to deal with that, wouldn't they?
It does appear that way, sir. Yes.
Yeah, okay, so it's implement traffic calming measures and or speed reductions to reduce the desirability. Oh, that's up Atiawa Street. Yeah, okay. All right. Okay. No, that's the only thing I really was had sort of scratching at the back of my head about. So that's good. Thank you for referring me to that. But apart from that, I didn't have anything else. Yeah. Thank you, Kath. Thank you, Mr. Church.
Thank you.
I've really only got one question of clarification for you, Terry. In your 117 of your summary statement, you refer to Mr. Brophy's commercial zone provision. Is that his sub-regional zone provision? Is that
just beside, I've got a footnote beside the 21 with a 1 on it, and the footnote hopefully responds to the right sub-regional zone provision, which is the R22, I believe.
Yes.
So I've recommended that depending.
Referring to Mr. Brophy's markup of the commercial zone that Mr. Bonas has done, are you?
There's so many versions, I would be lost. I understand I'm referring to Mr. Brophy's R21 and R22 of the sub-regional zone, but I could be wrong. I'd have to refer to Kat.
Mr. Brophy's got two or each way in his evidence, he's got a sub-regional zone, and then a markup of commercial zone. So I think you're trying to perhaps point us to the same provision, but it's different places in those two places.
That's correct.
Great, okay. So with that head scratcher, I think we can take a break.
Well, actually, sorry,
before you-
can I've forgotten there was one other thing I wanted to talk to Terry about. Mr. Church, you did talk about how even with the implementation, and it was in the context of the Hamblin site, in the context of the work that Blue Haven have been conditioned to do in the context of their development, even when they're up and operating, we're still going to have a LOSE AM and an LOSF PM at along that section of road there, which was one of the reasons you said that there's no room for Hamblin to some extent. I think that's how I understood it. Is that right? There's no because
I wouldn't say that there's no room.
Okay.
I just don't think there's been an assessment yet. I've suggested that there's likely to be little additional. Well, there's little additional capacity. The way that we measure capacity, I guess, in an intersection is through its degree of saturation, and it's measured at 0.85 or more. So what that means is that you've got very little capacity to accept additional traffic. Now, at 0.85, you can quickly rise to theoretical capacity of 1, which means you're saturated. But it all depends on the extent to which they're adding traffic to that. So if they add, if the development proposal for that site was to add, say, 100 vehicles, that might just tip that well over 100. It might be 20 vehicles that tip it over 100, but you're within very small thresholds. And that's why I guess my view is that there's still no transport assessment to demonstrate whether or not the intersection upgrade delivered by the Blue Haven site through that condition or through that provision is able to accommodate additional traffic. There's just no transport assessment to demonstrate that. It may be able to cater for additional 20 trips. It may be able to cater for additional 100, but it all depends on what that threshold is between 0.85 and complete fallover. It is operating at a level service F, which would suggest in the PM peak, there's not much left over, if any.
So this is a sort of scenario where you say that changing the zoning and making it a matter for consenting in the future is what, giving false hope, and it's just not appropriate, that you'd want to at least know whether there is capacity before you even put them in the ballpark of having a zoning that was different, which could potentially give rise to the traffic movements.
I'm of that view, but I'm also of the view that if you zone it to mixed use and allow for those activities, commercial, and you allow those high traffic generating activities such as a drive-through restaurant or a service station, it's going to be very hard to decline that, in my view, because they're actually enabling, or the zoning enables those activities, and it's very hard to sometimes push back and say, well, your trip generation is over and above, and you're not providing for a safe network and a safe response. So I think what you're doing
I take the point.
By zoning it, we're giving them false.
Are you going to be? I'm sorry.
No, you go on.
No, I'm getting a little bit of feedback and stuff. I was going to say, are you going to be available for us to talk about the Bro Devon and the other sites further north tomorrow?
Yes.
Because presumably the same issue applies, doesn't it?
Essentially, very similar, I guess, to the bottom sites of the Bro Devon site, so the 680 Devon Road. Slightly different outcome for the sites further to the north because of their restricted access in relation to restricted movements onto the state highway. But
Okay,
yes, I'll be here tomorrow morning at 9 a.m.
Brilliant. All right, we'll talk to you about that then. Thanks.
Thank you.
Thank you. Thank you, Alan. Thank you, Kath, and thank you, Terry. We'll see you tomorrow morning.
No worries. Thank you.
Right. We'll take a 10-minute break and then take it over to you, and we'll go on with your case. Turn it 25 before.
Trees and elders and forums. not my paper either.
Excellent.
Very nice paper.
I think we're just going to resume. I see there's some providing Coca-Colas along the road here. These are quite long days. You know, probably signal that we'll put this up around 5 o'clock. You feel that tomorrow. On, going beyond, gonna, it's awesome. So let's just do that and we'll finish tomorrow. So yes, Kate, thank you.
Thank you, sir. And normally I'm not one that gets told off for speaking quietly, but I have got a bit of a COVID croaky voice. So if I start fading, somebody will have to tell me to speak up. So going through my submissions, I don't intend to read them verbatim, probably for that reason, but also the succinctness that Ms. Wallace has gone over some of the same matters as myself. So I intend to focus on the areas where we've got some significant differences. And in that regard, it's been helpful for me to hear and have the advantage of the questions that have come from both commissioners and particularly from Mr. Littlejohn and asking Ms. Wallace on some of those questions and in raising some cases. So I wondered if it might be helpful to go to those cases that were raised in questions, if he asked some questions around distinguishing those before I start into my legal submissions, if we want to go into that specific issue around the existing environment, or I can sort of segue and weave those into my submissions. I'll be guided by Mr. Littlejohn as to what you prefer me to do.
Do you have a preference, Kate?
The latter.
So in terms of these submissions, Blue Haven has sought for a commercial form of zoning, and it did so, as correctly noted by Ms. Wallace in her opening submissions, with very broad relief. And I just want to highlight there that it's important to note, given some of the submissions from council, that those submission points sought relief that included activities other than what was in the consent. There was a number of permitted activities sought that were beyond the consented environment, although it is noted and very much being the position of Blue Haven throughout, including by the planners and economists, that the effects that were assessed as part of that consent in terms of Section 32 analysis have formed the basis of what they have put forward to support that zoning. So I think that difference is an important one. It's not that it limits the scope, but it does very much inform the premise around the suitability of zoning that's been sought, and permitted activities that were sought in the original submission beyond the consent were those that were considered compatible with it in terms of compatible in effects or less in effects. And that's what's been put forward. And Mr. Brophy can go over that in detail. I know we've moved on somewhat in that, but in the context of the legal discussion on scope, I think it's important to lay that out.
Are you reading from somewhere here? Or
Those are just me talking about where our submission started in paragraph 1.1. In the context of the strategic chapters hearing, as noted, there's been several legal memorandum, telephone conferences, commissioners' decisions to try and establish a collaborative planning framework. And that's where there's been a facilitated pre-hearing meeting following directions from the commissioners, as well as 4 independently facilitated expert conferences. And in that regard, I have also referred to the interested submitters who were invited and attended those sessions, as well as follow-on economic rule-say statements and the 4 expert witness statements. I've also noted in my footnote, there was a joint witness statement that was derived out of outstanding issues on the consent itself that involved two other traffic engineers from Waka Kotahi and also from Blue Haven. There was Mr. Appledorn, Mr. Graham Doherty, and Philip Brown. Turning to the rezoning requested, as noted in terms of relief sought, similarly, we've approached the adoption of scope to be one that sits from the existing industrial zoning going through to the special purpose zoning that was sought in the submission and anywhere in between. With reference to witnesses, I've just noted there the list of the witnesses who will be presenting evidence, and they are all here today and have been listening today. Now, I believe that they're all familiar with the commissioners, but I can introduce them now if you'd like. We know them all?
Yes. Thank you.
In terms of going through the outline of submissions, I start with legal framework, then go into the planning framework, focused on the areas of disagreement and the expert evidence. And I note that that's the expert evidence that we'd seen when I wrote these submissions. There's been further areas that have come up or evidence from Ms. Marco that I haven't even had a chance to read today. That may be other matters that hopefully my witnesses can look at overnight and discuss rather than myself.
Yes.
Really?
If you need to.
Thank you, sir. In terms of the legal process, we relied on the case law of the Colonial Vineyards decision in terms of section 74 and section 75, and then the section 42A report in terms of the accurate summary of the mandatory legal requirements and relevant settled case law in that regard. I've stated I don't intend to restate those tests, but I do note that the two matters that seem to me to be in focus today are giving effect to the higher order documents and also the reference to the national policy standards relevance in the context of what is the most appropriate zoning and where that sits in the parameters under section 74 or 75, or more importantly, where it doesn't sit in terms of importance. And there I've cited the King Salmon case in the plan change context in terms of giving effect to and the strong directions around that. And also the definition of environment in section 2 of the Act. And there I've gone into in 5.5 the Hawthorne decision around the word environment and its wider meaning. And perhaps I'll use that opportunity there to highlight some of the discussion around the case that Mr. Littlejohn referred to, and is it Barrett and Taylor as an environment court decision and existing environment, and whether this consent is fully the existing environment or whether it sits within Hawthorne in terms of being an unimplemented consent. And I note I had a quick read of that, and it appeared my learned friend was on the losing side of that, which perhaps may be why he remembers it perhaps better than others. But myself, I also have a case that I lost that I remember quite distinctly as well. And that's a High Court decision that I wish to cite where I lost on a similar argument put forward, which was Classic Developments versus Taronga City Council. It was a High Court decision, 2020, 945. And at paragraph 45, that was a commercial development that was out of zone from a centre-based approach in the Taronga plan. And it was a stage 1, stage 2 consent that was then relied on as a basis for a commercial development. And the High Court declined my argument to say that based on the fact that only stage 1 had developed, that the planner shouldn't have relied on it as existing environment. And the reason they did so, they cited the Court of Appeal case of Ngāti Kaho iwi with Far North District Council, and said that when it was a stage consent, if it had effectively been given effect to, it couldn't be you couldn't take it in a half, if you like, whether or not it would have only got halfway through implemented, if it had been deemed factually to have been given effect to. And again, that factual inquiry case, and I note that Mr. Littlejohn's case in Taylor and Barrett similarly referred to scale in terms of looking at the factual inquiry. It's about the complexity of consent and the scale of what had been undertaken. And in my submission, the Taylor case can be quite clearly distinguished on the facts. This is a much more complex consent than a simple dwelling that sought a consent to exceed the airport height. This was a consent that was specifically needed to deal with the contaminated nature of the land itself. And the stage one is solely dealing with the contaminated nature of the site. And therefore, in my submission, it sits much more on all fours with the High Court reasoning in the classic decision that I cited, and similarly on the Far North decision of Ngāti Kahu, where it's a staged consent. What was needed for that consent relied on matters which have been given effect to. And therefore, in my submission, it does form part of the existing environment and can't be broken down into parts when looking at what forms part of that existing environment. Turning to 5.6, I've raised section 5.1.
Can I just, let's have a discussion about that, because you actually haven't addressed the point. The essential point was, I think you said that because consent was required for earthworks related to contaminated land and those works have been done, then it does come within the reasoning of Judge Kirkpatrick in the Turner decision. And if that is the case, and I'll have to go back and look at the AEE because you haven't referred me to it, then yes, I will accept that if the works that have been undertaken on site were works that required resource consent, then yes, the works have effectively been done. So you are not in the same space that Ms. Barrett found herself in that case. The more valid question, Ms. Barry Pacino, is whether that is of any relevance to the future environment, because one interpretation is simply that by giving effect to the consent, you've prevented it from lapsing. But having gone to the site last week, it is abundantly clear that that the consent is far from implemented. So where do you sit on the notion that whether or not it ought to form part of the environment for assessment purposes, it needs to be established that it will likely be implemented?
In my submission, it forms part of the existing environment. I accept that for the purposes of zoning, it's not a duty that's falls on the commissioners that then follows that it must be zoned or recognised. But for the purposes of looking at good planning, you have a consent that has been deemed to be implemented. It forms part of the existing environment. It's had considerable investment in it to date in terms of getting towards it practically in terms of implementation. And
so I think we're still talking at cross purposes, and I think we've got to be very careful about the language here. You're talking about a consent having had some work done on it such that it won't lapse. I'm asking the question, has it been implemented or not? Those are two different things. Implementation, in my understanding of Hawthorne, which you've referred to, is that it needs to be factually established that it will likely be implemented. Now, the fact that it might have been given effect to such that it doesn't lapse is an entirely different question. So what's your submission on that?
That factually it has been given effect to and it will be implemented. There's no.
What's your evidence that it will be implemented?
The level of investment that my clients have made and continue to make towards that, giving effect to it and implementing it, is such that they have already, and it was described in the evidence of the strategic chapter, and it'll be further provided by Mr. York, that in fact they are underway with obtaining tenancies for the site, that they're doing planning for the site, that they've undertaken stage 1 of the site. None of those were done lightly on the basis of a consent that hasn't been implemented. The reason why there was an advice note put in the consent around the contaminated nature of the site was because of the level of investment in the site up front before they could get underway in terms of what that meant for them, because that meant a commitment of implementation that a bit like, I suppose, a significant level of investment around implementation that needed to be done before they put up buildings as preparatory works. But in my submission,
but if I understand,
actually,
if I understand Mr. York's evidence, that investment is probably not even 5 or 10% of the total investment that's proposed here. So yes, in real dollar terms, it's a lot of money, but in the context of the scale of investment anticipated here, it's relatively minor. But I guess what you're saying is that you accept my proposition that this is a matter I ought to talk to with Mr. York in order to ascertain what the evidence is as to the likelihood of the consent being fully implemented. Is that right?
Yes, it's a factual matter, and in
Excellent.
my submission,
We agree.
yes. But in my submission, the evidence is that it has been given effect to and forms part of the existing environment. I accept that the words giving effect to fall under section 125,
Yep.
But for the purposes of existing environment and how that's been treated by the High Court, in the case that I cited, existing environment doesn't necessarily mean that all parts of that consent have been given effect to where it's been treated as existing environment.
Well, it might be helpful if you provide me with those cases then, Ms. Barry-Pacino.
I'm happy to do so, sir.
It's circulating through the administration
Yes.
team.
So in terms of section 5.1 and the purpose of the Act, in the case of the Blue Haven site rezoning, the council and other submitters' expert evidence appears to lose sight of the fact that the RMA remains an effects-based forward-looking statute. Its overall purpose has not changed since enacted in 1991 to promote the sustainable management of natural and physical resources. That includes not just the CBD land with the council as landowners of those resources, along with other private commercial business owners and operators, but much community and citywide considerations. Blue Haven made considerable investment in the city and improved a significant city gateway site that was abandoned and contaminated, but also of cultural importance due to its relationship of the site with the adjoining Aituri Pa on Hapu land. The Blue Haven Centre, once operating, will offer the local community as consumers enjoyment of added variety of social, entertainment and cultural amenities. The Blue Haven land use consent was a leader in facilitating active tangata whenua engagement in its land use consent, seeking involvement in the early stages of its planning to provide opportunities for development of Māori land and protection of sites of significance. And that remains the case in terms of working with the hapu in terms of developing that and going forward and the aspirations for that adjoining site. These outcomes are identified in MOU, but will be able to be solidified in policies through the plan rezoning, and Blue Haven supports that. It's noted that other than the central government agencies, there are no other submissions or further submissions that have opposed the Blue Haven Centre being rezoned. Local hapu Ngāti Te Whirikura and adjacent owners John and Mary Hamblin support the rezoning of the Blue Haven site as sought, and I note there that both sites also seek rezoning from general industrial as notified. The council evidence has focused on the land use consent adverse effects on the economic viability and vitality of the CBD, rather than the positive social, economic and cultural effects associated with the Blue Haven Centre. The relevant section 32 assessment is to assess the effects of the proposed change to zoning, not the land use consent, as that already forms part of the existing environment. I've noted there that those are in terms of the area comprising a land resource that must be managed sustainably. In the context of the proposed district plan, the sustainable management of the Blue Haven site involves an area that has already been enabled for urbanisation for many years as a heavy industrial use, and that led to extensive land contamination and destruction of an adjacent cultural site of significance. The evidence filed in support of Blue Haven's submission and the joint witness agreed statements, which confirm the proposed district plan industrial zoning is not the most appropriate, and either a special purpose zone or commercial zone is reasonably practical alternatives. And finally, any potential effects on the environment which can be appropriately avoided, remedied, or mitigated through a commercial zone or special purpose zone proposed provisions. Will the special purpose commercial zone be more appropriate to recognise the Blue Haven Centre as reasonably significant, which has been as stated in the evidence? And I just want to just circle back to Mr. Littlejohn's question around the what if scenario, and it seems to have been raised repeatedly through other evidence as well. In my submission, even if we ran that scenario and did it to exhaustion, let's just say Blue Haven Developments went bankrupt tomorrow and walked off the site, and I'm not sorry to Mr. York, but it wouldn't be the first time that those things happen around New Zealand or overseas. So let's just run that scenario out. What you have is a piece of land that's had considerable work on it in terms of removing what was there as contamination. However, I would note that in terms of zoning, there's a couple of matters that come into play factually around alternative zoning. Residential zoning requires, if it was at ground level, considerably more remediation than what's required for a commercial zoning. And therefore, in my submission, it practically speaking would be cost prohibitive to go into a form of residential zoning, let's just say as an alternative scenario. In terms of the work that's been done on it, it's also, in my submission, not practically feasible nor likely to ever revert to industrial. But more than that, what did come out in the pre-hearing, and Naimata Skipper, if she's presenting evidence tomorrow, can certainly speak to that herself, but it was spoken to her that from the Hapu's perspective, the industrial heavy type uses on that site, they considered were culturally, and I think actually she may have spoken to this, to the commissioners at the strategic chapter as well, that she didn't consider that they were appropriate in terms of recognising the importance of their land and that locality and its cultural importance. So in my submission, even if you put aside those matters, you are still left in my submission with some form of commercial zoning that would be appropriate for the site or should be enabled. And it's looking at that, even if the commissioners felt that in their decision making, they had to put in place some risk analysis of, let's say, the first stage was completed and at stage 2 or 3, even, that something happened. And I'm not saying that it's not reasonable to weigh up those risks of acting or not acting, that's your role. But what I am saying is part of that is also a factual analysis around what's reasonable and likely and feasible in the context of a site that's had the extent of work and investment in it so far. And also what's consented. So anyone that picks up that site, let's just say you do have a consented environment that, in light of what's been argued, would be relied on realistically by anyone going forward.
I'm just testing those reasonably appropriate zoning options. Site, as I understand it, 7.5 hectares. Rail access or not? Is there access to the rail line through the current easements or anything? It used to be, didn't there?
Old rail siding there, but I think the easement is the extinguished through the Raven Sound subdivision.
Yes. Couldn't be re-established.
Could be.
You're near a port. Yes. So, look, it's very the scene at the moment. You can certainly add in my practice as a planner working for big industry is that type of large site putting aside the cultural issues would be quite unique.
Well, in my submission, again, the rail has been removed from the site. It's been reworked to the point that per square meterage would never meet in terms of market viability when there's actually, as noted by yourself, a capacity of industrial other large sites that actually are underdeveloped currently. So in my submission, the chances of that occurring where it sits in terms of relationship with mixed use zoning all surrounding it, residential, its relationship in terms of the cultural land beside it. There are a number of factors that mean that it's just not realistic factually that it would revert back to industrial.
Point I was going to raise is there is quite a bit of height differential to where the existing or the previous railway siding is to the current site. Be problematic physically to actually connect the two. More of a checkbook, a bigger checkbook.
Thank you.
So I then just cited section 32, which I just would leave take as read, but I have noted there that there has been additional analysis undertaken by both Mr. Bonis, Mr. Brophy, and also Mr. Thompson in terms of his gravity model around the section 32 and 32A analysis, and that has been done out of an understanding and need that's come from those joint witness caucusing and what was required through that process and what was considered needed. So there has been considerable work since the plan is notified around those matters. And I've then similarly to Ms. Wallace cited the Albany North landowners decision around that in terms of section 32 and the primary function of a section 32 analysis. And in my submission, I consider that there has been detailed further information sufficient to give the panel confidence around what's been prepared. And I've also noted there in terms of the retail gravity model prepared by Mr. Thompson, and I just perhaps again probably take this opportunity to segue there into some of the criticism cited at that by Mr. Heath. And I would just note that in terms of economic evidence that's before this committee, there's a very limited amount of robust data provided to justify both the strategic chapter and the hierarchical model that it's presented with the plan as notified. There was not a gravity model done or prepared for that process. Mr. Thompson has done that because of the significant effects that were raised around the effect of the Blue Haven Centre on the CBD. He hasn't done it beyond that to the other centres because that was not what was raised as the rationale as to the primary reason for objection. But in my submission, if there was an aspect to where there was economic data lacking, I would suggest that was done at the time of the preparation of the plan under section 74 and 75, and the 32 reports that were done to the plan as notified, rather than Mr. Thompson's evidence and his gravity model. His gravity model has confirmed Mr. Heath's data, and Mr. Heath stated that he considered that that was based on luck. In my submission, I would suggest that was lucky for Mr. Heath rather than the other way round, because it's Mr. Thompson who has done the economic mathematical analysis one would expect before putting in figures around estimates. And in that regard, Mr. Thompson can talk to his data and his gravity model more thoroughly. I suspect it will be tomorrow, but I did go over with him some of the matters raised by Mr. Heath. He said there's one erratum on the number which was first raised by Mr. Heath, which he can correct, but other than that, in fact, the data and the forecasting is correct, and he can speak to that more tomorrow. In terms of the Section 75 and the scope of the submission, again, I note that Ms. Wallace has also spoken at length in her legal submissions on scope, so I don't wish to retraverse matters that you've already heard and likely familiar with in terms of citing those cases. I would just highlight again the concern that I have of attempting to limit Blue Haven's submission in an unnecessarily artificial manner by saying that it's limited solely to our consent. That may be a matter that the council seeks in terms of limiting effects or in terms of Blue Haven relying on it to assess effects for Section 32, but that's different in my submission than an element of scope. I have then discussed the national planning standards, and it was gratifying to hear Mr. Bonas also concurred that they shouldn't be adhered to with mathematical precision, because I think we're in agreement on that matter, that they were put forward, and my submissions on this are really about the purpose of why they were put forward was to try and cut out the unnecessary work that New Zealanders were feeling frustrated that every district plan might have a different definition. And it was really quite simple on matters where it came to definitions and trying to say plans should have a simplistic approach to zoning, that you could go to a district plan around New Zealand and understand the zoning. And it works well when it came to, for example, the larger cities like Wellington and Auckland, where those zonings and those came through, and they helped develop those through their first plans, and they've worked really well for them. But in my submission, Plymouth is struggling to make this work, and seeing other councils come up for myself that are up for review right now, it's going to get progressively harder for the more provincial cities and smaller cities to make some of those, particularly the commercial zones, work for them, where they've got existing, for example, standalone centres, or matters where you might have a commercial centre with no residential, when you've got rules that say you don't want residential in there, or you've got small things that don't fit to be a metropolitan zone, then when do you fit it in? So I don't think New Plymouth is going to be the first district council to grapple with these issues. And it's hard, and it does mean that it's going to get a bit clunky and not be as perfect as everyone designed at the time when these national planning standards came through. But I think if we look at them as they're there, but they're not there to the point where it starts becoming anomalous planning policy outcomes, I think is the way that I suggest that the commissioners approach these planning standards. And I still come back to that actually it appears that all the planners agree that there's two most practical options of the even commercial zone with a precinct overlay, or the special purpose zone with an overlay. And the elephant in the room that's been aired today and is very clear that the only difference between the two, and why it seems that there's a really strong push for a commercial zone, comes back to whether or not this site should be recognised as a centre within hierarchy/network.
No, we're certainly grateful for the work that planners have done, trying to put a square peg in a round hole in terms of this local environment. I think just on reflection, we would have had an enviable task trying to work that out about the assistance of the panel. So we take that. So we are being narrowed down by those joint witness statements, and there was a good level of agreement. So that saying we're struggling with the divergence of opinion on the key effects issue. Yes. Thank you.
So then moving to the planning framework and the NIPSA 2020. And again, in my submission, I think it's important to also look at the broad policy objectives of that rather than the strict mathematical exercise of giving effect to where many of the policies are about enabling. And I think Mr. Littlejohn picked that up with objective 3 and the questioning to Mr. Bonis that the NIPSID importantly doesn't direct, for example, a centres approach or a hierarchy. It doesn't have a maximum capacity. It has an at least sufficient type of terminology and some of the wording around capacity. And it has a very strong, background underlying policy framework where it was trying to force the councils to be less restrictive. And I think it's important to look at that background and understand, well, what was its overall intent? And its overall intent was primarily around residential land, but also business land, to say less strict adherence to let's enable and make things happen within a framework where it makes cities a better urban environments to live, work and play in around that framework. And I would accept that all the planners have worked towards that with looking at this centre, but it's how much does it become sort of a stick rather than a carrot in the framework of the policy and what this plan looks at around this Blue Haven site. And I think that's where the difference lies. And if I can just summarize there a little further, it seems that the difference there is really around, should the policy framework be such that the existing consent becomes something that anything beyond it is treated as adverse and stopped, as opposed to looking at this as an urban zone, regardless of whether it starts off as industrial or otherwise, it's infrastructure ready or enabled in terms of what's expected of it, and that's come through to the plan provisions. It's there and it's sought to be enabled in a way that allows it to be addressed to give Blue Haven some flexibility around when it goes forward. And I note that Mr. Bonis says that in his opinion as well, he concurred that by the time you get down to detailed design, things start changing. And that's a reality that I think for most planners in New Zealand in dealing with consents that are complex, go over a number of stages, go over a number of years, there's usually some moving parts in that. And it's how best do you approach that in an efficient manner that these plan provisions are sought to address. So I've focused there on objective 1 and 3 in terms of looking at that being well functioning, about whether or not it's near other centre zones or employment opportunities, whether it's well serviced, and whether there's high demand for housing. Now, some of the factual matters around that, which Mr. Brophy can touch on more in his evidence, but it's covered that he's saying, in fact, that this site is within 800 metres of the Fitzroy Centre site, that it is near the residential growth area in the Glen Avon area, that it is an area that's well serviced by planned or existing public transport, and that it is adjacent to a number of mixed-use zone areas surrounding it. So in that regard, the Blue Haven planners evidence is that it does fit within these objectives for business land. Mr. Thompson's evidence is around that difference between being sufficient, being a minimum, as opposed to a maximum, and that this site addresses being more ready, if you like, in terms of having no impediments around it to address business capacity in the district. In terms of the regional policy statement.
Before you go, I asked a question about the council team about the NPS UDC and Adam's rights on that in terms of what, vacant ground level land is what that's anything that can be counted in terms of commercial land vacancies. So we're not dealing with the UDC anymore, are we? But can you just rationalise that its use in that context?
My understanding of that, from both Mr. Thompson and from dealing with Blue Haven and numerous other development clients, is it's the costs around going up that are the impediment. When you start dealing with relying on business capacity going up, that it's about the attractiveness of that in terms of market feasibility or market attractiveness. That for market players looking at capacity, they deal with what's at ground because of the cost factor. But I don't want to give evidence on that, but that's my understanding of it.
Use of the UDC
As a
guide. Or
as a guide.
Yes.
In my submission, the urban development capacity is one where it's focused on minimums and it's about enabling. I don't think it was intended to start, and it doesn't specifically refer that you can only, if that's your question, I'm just struggling to understand.
Adam relied on visions of the UDC.
Yes.
In terms of how commercial land should be judged.
Yes.
That's the definition or a metric for a vision on the UDC. All I'm saying is that legally the UDC is functional now. So, how much can we rely on it? We should rely on it from that.
Now that the 2020 has come through.
Yes.
Well, if it's not the same definition that's carried through into NIPSA 2020, has it got a different definition or it just hasn't been carried through at all? I'm not sufficiently au fait to know that the difference, I know it's been replaced legally, but if one hasn't carried through at all with a differing definition, I think putting aside that one's replaced the other, if it's not been carried through as a definition, then you've got a gap. But I think more than relying on that one replacing the other, I think the practical issue for my rationale around why one should practically rely on what's at ground level relates to the reality of what retailers look at when they're looking at what's feasible or desirable in terms of where they locate. So that's probably not answering your question directly legally, but I acknowledge that one's replaced the other.
Yeah, I think there might be a gap.
Yes.
I'll check with Adam.
Yes.
And the new didn't have it.
So if there's a gap, that's interesting. One would wonder why. But if it's one's been deliberately replaced by another, that I'm not aware of that difference and why. But practically speaking, I know the evidence from Mr. York and other developers is around cost.
Thank you.
So just in terms of the Taranaki regional policy statement, it's acknowledged that that was prepared in 2010. I do note that it didn't have a centres policy, and I do note that numerous other regional policy statements of that time did in fact have centres hierarchies that were developed, and this one didn't. So it's, in my submission, the centres hierarchy approach in regional policy statements, it's not a new matter. It was around long before the NIPSA 2020. And to my mind, it's more interesting that that centres approach is not reflected in NIPSA 2020 in relation to business land. So I think it's also interesting that the Taranaki District Regional Council hasn't submitted on any of the commercial zones. And they hasn't chosen to get involved. I don't know why.
I wouldn't read too much into that. We've seen once briefly in a year. Doesn't seem to be the focus. It is what it is.
It is what it is. I did note that they did say in their submission, and I just wanted to acknowledge that they said that they'd been involved in the draft plan. So there appeared to have been some collaboration and consultation in that process, but beyond that, I can't comment. In terms of evidence and areas of disagreement and issues for determination, I have noted there that there was some really positive outcomes, and there seemed to be a strong collaborative approach and intention, including that everyone agreed after the first planning statement that they, joint witness caucusing, that they needed a second one, and that was done. Similarly with the traffic joint witness statement, I'm not sure. I think that, yes, the differences in economists, I would concur with Mr. Littlejohn that in my experience, I've never seen economists work productively on joint witness statements or evidence ever. And it's just part of the territory. So I'm not sure what that is. It is what it is. It doesn't make your job any easier, and I certainly know that it didn't make the planner's job very easy in their caucusing either, because the intention in terms of timing sequentially was that one was meant to inform the other.
I had briefly flirted with the idea of wishes about getting one independent and another third economist. But then I thought, well, that might be discussion places that might be sorted.
This ends up in bullying. Yes. So, having said that, there was some points, and I know Mr. Heath pointed out one, but I'd like to point out another, that they did both agree that the consent formed part of the existing environment. It may seem trite, but it was an important point that they both agreed on, and so that should be acknowledged. I think what I highlight in my submissions, and excuse me if I was venting post-COVID, but the frustration that I found was that when the evidence came out, it seemed like a lot of that good work had been undone or seemed to like go back to square one in terms of what was presented, particularly over matters, for example, such as greenhouse gases. And I know Ms. Heathwaite seemed very upset that I criticised the process in that regard, but if it was such an issue or one that was discussed, one would have expected that it either said it was an area of disagreement or an area of agreement. And then it could have been addressed through provisions that were put forward by Mr. Brophy at the time. But I do note that in terms of that, the provisions put forward by Blue Haven have included, and even the consent itself right from the outset, the council did address those issues. So there was electric vehicles, they call them stations, there was cycle stations, there was the intention of always putting public transport through. So those matters were actually considered at consent stage by the traffic teams involved, and that did carry through to the provisions. So again, it was understood that those were matters were put to one side, and it just becomes disappointing when these things come up that could have been so simply addressed and put to bed. And that's where that concern comes through. And the other concern that I have, I suppose, is the continual what if but for scenarios around the consent, and whether or not it should be given weight as part of the existing environment. In my submission, the joint witness statements stated that it was and formed part of the existing environment, yet then when the evidence came through, the suggestion around whether or not it should be considered as a sunk case cost or not, or whether or not it was part of the existing environment or not. Now, maybe the language as suggested by Mr. Littlejohn around whether it's existing environment or given effect to environment in terms of the section 125 matter, but in my submission, for the purposes of the zoning and the submission sought by Blue Haven, we sought that it be recognised, and the policy framework put forward was on that premise.
Would you agree that despite these areas that you don't think could have been done better, that the joint witness statements on the whole are very helpful?
The joint witness statements are excellent and very helpful. That's what I'm saying. It was great.
There's a couple of, but okay, I've got that. But I just want to put on the record that I agree, and I think reading between the lines, Commissioner Matheson had a big role with that. Got the pass our thanks on to him for pulling that all together. We certainly felt that it did need an experienced policy planner to really through. So I think, yes, if you just record that, Sarah, that would be great.
And that's why I've stated in my submission, I think the panel can rely on those in terms of those joint witness statements, that I think they are robust and helpful. And really, in terms of where I've gone through at 7.6, the evidence, I have noted there that Waka Kotahi's technical knowledge of the planning provisions and Paengaroa, where I've said there was the technical knowledge at that point, is that Mr. Bonis and particularly Mr. Brophy have lived and breathed these provisions for quite some time. And I note that Ms. Hepwaite's given further evidence today with changes to the provisions so that she's now also, in terms of transportation matters, given extensive technical knowledge, and that's acknowledged around the transportation matters. But in my submission, you know, the planning evidence of both the council and Blue Haven in the context of the district plan as a whole is one that they are very familiar with around all of the matters involved, and that their provisions and suggestions in terms of what's been put forward should be relied on. And most of the Waka Kotahi matters, at least up until today, and I can't comment on today's because I haven't even had a chance to speak to Mr. Brophy, but most of those were adopted by him in the table evidence that we circulated. It was submitted over the weekend, where most of Ms. Hepwaite's suggestions for changes, Mr. Brophy's adopted. I think there's one that I think he's questioned, and I don't know about the others that have come through today.
I just don't think we should focus too much on criticising the state of knowledge of processes designed to really bring these matters to the evidence. And, move on.
Yes.
Yep.
And then really in terms of the theoretical economic evidence, I've stated at 7.8 and 7.9, what I think you've already recognised, that that's the main area of disagreement. And that's the area that in my submission is going to come down quite heavily, both in terms of the strategic chapter as well as the zoning, and that one is intricately linked to the other in my submission, that they do go together in terms of the position put forward, because Mr. Thompson talked in his evidence on the strategic chapter that he had fundamental differences of opinion to Mr. Heath on the strategic chapter, and I think that's flowed through to the subsequent evidence on the zoning as well. Seven point 10, I've covered that. The evidence of Mr. Brophy and Mr. Batchelor is that the special purpose zoning is the more appropriate zoning to achieve a coherent vertical integration within the proposed district plan as a whole and consistency with the national planning standards. And that the economic joint witness statement is also in full agreement of the regional reach of the centre. And I think you'll note that the evidence of Mr. Batchelor makes an interesting point that the focus around it being a regional centre works both ways. The council's evidence is that it's regionally significant because of adverse economic effects that potentially it could have of such reach that it's regionally of significance either way. But then there's a question around if it's either way, then shouldn't it be recognised in the centre hierarchy as much for drawing attention to its importance to be managed appropriately? And I think there Mr. Bonis has referred to one of the strategic chapter provisions that's about protection of those centres. But if the strategic chapter is more about recognising the role of each of those centres, and I think Mr. Brophy's evidence is that the CBD has, he acknowledges that the CBD has primacy, but what he's saying is that, and this was given in evidence at the strategic chapter, is that the strategic chapter should recognise more of a network approach beyond the CBD having primacy by nature of all of its civic and public amenity features. That, and as a primary employment zone, and the fact that it's obviously by far the largest area as well, that then you fall into that each of those centres has a different role and function, that they all complement each other and have a different role as opposed to a hierarchical one. I mean, I guess it's a question of there's a size, but there's also a function, and the two in a hierarchy, how do you deem it? Beyond the CBD being the primary function, if you follow that each of the others sit within a network, and this is what I think Tauranga has a hybrid model, if you like, of a hierarchy and a network. There's a spatial plan, the back of a plan, and Mr. Batchelor can speak to that more succinctly than I can, but it has a network with different circles, and each is given a role, but it's not in a strict hierarchy other than the CBD being at the top. The others are treated as different, as in they might have a suburban role, or which this council's district plan sort of does, but then it does attempt to shut down and stifle others in quite a strong way, as opposed to a recognition of an enablement and supporting role. And I would note that when I was looking at evidence on this issue in case law, I did see, and Mr. Littlejohn may have been involved with this in Auckland or yourself, but that that the Auckland Unitary Plan had similarly a lot of centre studies that grappled with combining all the different district councils and their centres. And the reports that I read came to a position where it said the standalone centres and dealing with them needs to try and support them to be more modern, more inclusive of visitor accommodation or residential, or providing some community activities, rather than trying to work out a restrictive regulatory approach to stifle them to benefit the CBD, and it came to a different approach. And all I'm saying is that it's not a simple answer of applying a hierarchical approach here in terms of the Blue Haven Centre. If it's recognised that it's a regionally important, for good, bad, ugly or otherwise, shouldn't there at least be a recognition in the plan that it is what it is?
I think you would have heard him talk about one of the biggest concerns for him was the office function.
Yes.
That's not provided for. Would that be provided for in this Blue Haven side as a discretionary activity in terms of appropriate schools?
So the consented limit is the limit.
1,700. So you think that in itself is a protection? Because I know I've seen some ugly, sorry, shouldn't use judgmental, these sort of office park facilities parked down in nowhere. they,
Yes.
they prevail.
Business parks that they put in industrial zones that then have become effectively office parks.
Yeah, but
Yes.
with no amenity.
Yes.
So your submission would be that the size and the consent, coming back to the often consent in, is the protection to guard against fear that he has.
Yes, and the other thing that I did want to note is Mr. Bonis has focused on that the strategic chapter and the concern around that being in the centres. But this centre also has very specific objectives and policies that have been discussed by him that give primacy and protection to the CBD. And the way that a plan would work, one would expect, is that the strategic chapter provisions are more general than the specific, and the specific objectives and policies are informing of the protection that he cites. So it's always going to be viewed in context, even if it was given centre recognition, that it sits below the CBD by the nature of the proposed objectives and policies, as well as the rule framework.
So the activity has to be pretty specific to avoid the type of office leakage that I think.
Yes.
Council's worried.
Yes, and I think that you've got a full discretion that it's got the activity status where it says where it will have a significant adverse effect on the viability and vitality of the city centre. So there's an as well as the town centre and the local centre. So it already puts itself within that hierarchy of the strategic chapter. So you have the ability to recognise it as a centre and still have objectives and policies as to where it sits. And then the expectation around looking at those matters is dealt with discreetly in the centre zone itself, as well as the strategic chapter. The only issue would be where there is a conflict, as I would see it, not so much with the CBD, but where if you said this was regionally significant, but it sat below the CBD, it would logically come second. And then there's a question around the local centres and the town centres sitting underneath that. And the other aspect of risk that Mr. Bonis raised was, what if in a mixed use zone, you had an attempt to revitalise those sites to put a matter in that then would come into conflict with this centre. But in my submission, isn't that appropriate? You've got, if this centre gets up and established as suggested as part of the existing environment, you have $200 million of investment in a centre that's modern, that's attempting to address urban design, cultural matters, efficiency, public transport. Shouldn't it be given recognition and protection in that regard over a mixed use zone? So I don't see where the conflict is in that. In fact, that's appropriate and what we're, the very reason we're seeking.
Yes. I think you sort of, I asked about the office function. I think you've gone way past that. But look, I'm conscious of time. I've tried to keep this thing down and just let you carry on through.
So at 7:13, again, I've just skipped over the planning and the differences between your guidance. I've then said in terms of the tensions that are obvious between traditional town centres and new commercial centres. And that's where I've said, where I've looked at other councils such as Auckland that have been through this process recently, that their reports talk about the importance of working with these existing standalone centres and private developers and providing a more sustainable form of residential employment and services in the future. And that this is a significant block of land with significant potential to provide a modern and mixed-use commercial development. And there I've discussed, which has been recognised by the council, I think, with the recent city centre strategy, but the establishment of more investment interventions by council to stimulate development potential in the CBD if it has got issues. And those are usually matters such as infrastructure upgrades into public amenity, physical environment improvements and investment in those matters. But I would note there that with the issue that I have somewhat in some of these matters, like the long-term plan reference that Mr. Bonnet has and the city strategy, is both these matters came through in 2021-22. These are after the plan was notified, after the Blue Haven consent was granted, and after strategic chapter 1 hearings as well, I think, in terms of timing. And I have some concern that if you talk about the tail wagging the dog, what the cynic in me is saying is that it seems to me that the council's doing a shoring up rearguard action to instill in its CBD some investment around the imminent threat of the Blue Haven Centre being established. But having said that, is that a bad thing? If this is what's taken for the council to step up and invest in its CBD and put some money towards it, to a city that, as Mr. Heath is saying, has already been in decline, and this Blue Haven Centre hasn't even got anywhere close to being established and is at least 3 to 5 years away before it's up and running, you would wonder why they haven't done it sooner. And those matters come out of investment. They come out of working with developers, and they're about partnerships that sit well outside the RMA regulatory framework to make happen. And I do accept, I've cited in 716 some of the cases that are contrary to Makura in terms of pushing back on strategic plans, but I think it really comes down to weight and timing of process. And that's where in my submission, although in section 74 you have a reference to management plans that a council can have regard to, the sequencing of that within the Act as a whole is one that I think is important, that the intention of it is that it's as part of section 74, that it's in time of the preparation of the plan that was done through a draft plan that was first established, as I recall, 2017. New Plymouth Council came up with its plan in draft. It then followed through substantively the same in terms of its hierarchical structure of commercial centres when it was notified, 2020. And at no point at that stage was it informed by any strategy management plans. This has come in the middle of the process and now being suggested to be given weight. And in my submission, I certainly haven't, or my clients aren't aware of a scheduled process for consultation that's involved any submissions that Blue Haven's been able to be involved with under the Local Government Act as a long-term plan process. Not that they wouldn't support it, and I don't think it's this case where Blue Haven, and I think Mr. Bonnet noted that they didn't. Blue Haven hasn't submitted against the city centre. What they've said is, why are you trying to attempt to stifle our development to attempt to build up the CBD? That's not a causal nexus or relationship between the two. That's been fairly established by the evidence. And that's where I have an issue with relying on this management plan or investment as a reason to justify the Schedule 1 outcomes that are being sought in terms of stifling the Blue Haven Centre.
Consultation, special consultative process. Whether Mr. Broken will aware of any other consultation exercise.
Yeah, I'm not familiar with the background.
I think staff are going to thank you.
And so at 717, I've just discussed there that, we started off in the strategic chapter seeking a zone that provided some flexibility and environmental standards necessary to meet the changing needs for shopping and decentralised employment as the community grows and expectations change. And it's really that we're seeking a recognition that centres all change over time, including CBDs, and a district plan that needs to efficiently and effectively recognise and support changing nature of a commercial centre. Said there that the property economics report doesn't demonstrate that there current and potential future oversupply of retail or reflect imminent market failure of the New Plymouth CBD, which requires intervention to resolve, nor has evidence been provided to justify a policy position that any issues with the CBD's viability or vitality might be resolved by the intervention in the Blue Haven Centre. And then I've discussed the need to be included in the centre hierarchy, which I've already highlighted verbally, but I've just basically said there, to avoid not putting it in the centre doesn't make it less factually. It's a logical fallacy that by not including reference to it, that the regional impact of it isn't the factual reality, and that by restricting one isn't going to fix the other in terms of the CBD. And in my submission, I consider that the evidence provided by Mr. Heath hasn't provided probative economic data on this issue. In my submission, Mr. Heath's evidence is more leaning towards a policy planning evidence rather than economic. And whilst that has a role in the RMA, it's not the same as economic evidence. And I've also said that there are numerous other potential changes that are well outside the Blue Haven Centre, such as broader economic changes, economic structures, retail structures, trends in decentralised workplaces that haven't been explored or weighted sufficiently to provide confidence in the outcomes projected as being linked to the establishment of the Blue Haven Centre, let alone a commercial zoning of the site. And I do note there and acknowledge that economics is a notoriously difficult area to nail some of those down, and COVID's probably displayed that better than anything in terms of making predictions. But I also note there that the evidence of Mr. Heath has criticised Mr. Thompson's evidence around not factoring in COVID sufficiently in terms of his economic forecast going forward. And in my submission, whether or not you said it was a couple of months before it recovered, or you said it was a couple of years, or you said COVID-led is going to head towards an economic recession, which worldwide they're saying is imminently about to hit. But the issue for this panel and the Commissioner's decision-making is that this plan is looking forward really 10, likely 20 years in terms of investment decisions that the market's going to make. And I don't think it would be appropriate to be looking at 2021 data when it was such an aberration in terms of those outcomes to make those decisions and define those to the extent that I think that's where Mr. Thompson's evidence is relied, but I don't want to go into that too much without ending up speaking for him on that issue. In terms of other submitters' evidence, I've just said there that I just struggled with the extent to which Mr. Campbell has taken such a strong policy position on the centre, given that, as my understanding and briefly looking at other chapters, you have a situation where the housing business analysis for the New Plymouth District Council is that it has sufficient housing capacity for short, medium and long-term capacity. And I don't, without going into it, my understanding is there's been nothing that I've seen that suggests otherwise. So the latest report that I read on that showed that in terms of that long-term residential capacity, there's a reference in the title to that to New Plymouth Central. It doesn't say the CBD per se, it says New Plymouth Central, but one presumes that one is a definition to equate to the other or is very close to it, but that it only accounts for 2%. So to that extent, if there was a suggestion that the Blue Haven Centre somehow would adversely affect the residential investment for housing purposes for Kaingora's policy approach, it's difficult to understand the extent of his concern there. And there I've also discussed that in terms of the Blue Haven site and the extensive assessment and widely limited notified consent process. So even though it was limited notified, it did have some 10 notified affected parties, including Wakakotahi, in terms of what was assessed when we're now looking at it as part of existing environment. And there, Mr. Campbell's evidence has talked about significant effects and negative consequences. And I've just said there that again, it's not clear whether that references reliance on Mr. Heath or whether it was relying on Mr. Bonis's evidence. But I think one flows into the other. So where other submitters have relied on the Section 42A report, one assumes that it's relying on both. He did state today that he briefly read the other witness, and I do want to acknowledge that. It just wasn't clear from his evidence as lodged. So in conclusion, the rezoning of the land sought through the Blue Haven special purpose zone provisions, together with the application of the precinct provisions attached to Mr. Brophy's statement, are, in the opinion of Mr. Brophy and Mr. Batchelor, the most appropriate outcome for the site, and will best achieve the board policy objectives of NIPSID and the purpose of the RNA. That the zoning and provisions now proposed align with the national planning standards, and I would say they're as best as possible, given the circumstances and difficulties that we've highlighted previously, and good planning practice, that they're efficient and effective, and again, as best it can be managed given the complexity. And the commercial zone alternative provided by Mr. Bonis does not align as well with the national policy standards by avoiding inclusion of the centre within the centre's framework and by rendering the wider district and regional framework provisions less coherent and effective. The commercial zone doesn't acknowledge the regional significance of the centre and the network hierarchy, and Mr. Bonis is recommending use as a generic zone type, which isn't not going to be planned to be available for other land in the future. Council has chosen to seek a prescriptive and codified approach to planning the future of its centres, which seeks to impose and maintain a particular order among them. This approach is not supported by Blue Haven or its experts, and Blue Haven seeks an appropriate zoning and provisions that recognise its significant level of investment and does not unnecessarily impede the need for flexibility in a planned policy approach. Blue Haven seeks plan provisions that address the benefits and amenity the centre provides to the community, recognises that changes are inherent in a commercial centre over time, while addressing infrastructure, cultural and urban design issues. I should add, and traffic issues. I omitted that not by intent. Blue Haven acknowledges the risks and likelihood of often significant and unpredictable economic changes over the next 10 years of the plan and beyond that may affect the CBD, the Blue Haven Centre and the wider region, but considers the interrelationship effects on the CBD from the Blue Haven Centre as suggested by council witnesses have been subjective and speculative. And Blue Haven requests that the hearing panel confirm Blue Haven zoning in a manner proposed in Mr. Brophy's evidence as modified through amendments to the provisions set out in the additional table by Mr. Brophy in response to other submitter evidence. And I would note there might be other changes given the evidence that's been presented today that Mr. Brophy may also touch on.
Before I ask Pip to deal with any questions, it's your first sentence of the 8.2 you just read it up. Okay?
Sorry, 8.2?
Yes, the first sentence. So that I thought you said that CBD does have primacy in your submission. You're saying there's something different? With no particular order, approach is not supported by Blue Haven experts.
Yes, I would change that because during the course of the joint witness statements and matters that move beyond, I think Mr. Brophy has recognised in his subsequent evidence that he accepts that what he accepts is that the CBD has primacy by nature of the fact that it's got the public and civic amenities associated with it and because of its size. But it's so he has recognised that in his subsequent evidence, not in his first chapter evidence, but I think in his evidence subsequently.
Would you cross out 8.2?
I think that what we're seeking there is that the CBD be recognised, but other than that, that the other centres are recognised more for the differences in their character, which by their nature, I guess, have a form of hierarchy, but they're different. I guess it's the different characteristics of them that change scale and purpose.
Thank you. Yeah. You've been quietly listening. Notes.
Oh, sorry, can I just add one last part to my submission? And that was, there was one other case that was cited by Ms. Wallace, and that related to the King decision. And I just wanted to distinguish that, if I could. I would note that the Hamilton City Council matters were matters that I was involved in those appeals. Mr. King and his site is one that I think Mr. York can also speak to, because he acted for the adjacent base site at the time. He was the chief executive of that, was also involved in all those appeals. And I was also involved in the RPS appeals that were prior to the district plan appeals. And I would just note that some significant differences. Firstly, that the RP, and I think it's noted in the decision itself, the RPS went through a contested appeal process